Right then, so we're really getting into this subject now very, very deeply and very specifically actually. When we get into the subject of election petitions, it's almost if they're describing and giving a very clear and understandable homage, if not tribute, to the right to petition Parliament as well. But this is covering the subject of what happens if anyone breaks the law or there's anything wrong in connection with petitions. So if you use the term and words election petition, if you think of it synonymously with petitions to the House of Commons, then it all makes absolute and complete sense, and you've got this like special procedure. Now, the thing is, we had the Tumultuous Petitioning Act, and it does set out procedures, special procedures in law. It does reference them, refer to them, special legal procedures. Now, that was all the way up till 1986. Now, the thing about the Tumultuous Act is this. If you only had a small number of people petitioning one case, under 20 people, then it didn't need to be put through or checked through a court, right, to ask what you're up to before you submitting it to Parliament. If it was over 20 people, then it had to get assessed by these a part of a grand jury or justices, right? So effectively, that solves a very big problem, because groups like Extinction Rebellion, which are huge and a nightmare for the police, or Just Stop Oil, or Stop ULEZ, or anything with over 20 people, would have its own official case management allocated for when they start, or if it got so big, it would have its own case management for the whole thing, all under one case. That would mean all of the Stop ULEZ offences, actions, use of banners, materials, the whole thing. It would actually have its own case management before, but then to the House of, but also the Petition Committee in Parliament after that, right? But so that controls large numbers of people, which is what Rishi Sunak's kicking off about. Oh, there's protesters everywhere, London's a nightmare. Well, if it was under 20 people, you didn't have to have that prerequisite check and case management. It could be straight into Parliament management. So what this does is it prevents all these, what Rishi Sunak and the Parliament now are complaining about, massive protests and demonstrations, and this discrepancy between who is officially covered by certain laws and who isn't officially covered by certain laws, who is officially engaged and not, and then Priti Patel with all the stupid public order bills and so forth, which effectively aren't even legally. There is immunity from. We'll get into the immunity. We'll see how the immunity works when we get into this, which explains a lot. And you're getting into the territory of judges breaking the law and them getting removed, but not. The punishment basically is the removal of the position. Same with MPs and really police officers as well. You're getting into that area rather than imprisonment or other criminal punishments, you see, because they've got immunity, and also the House of Lords with privilege. But even in these special processes, it accounts for the privileges, like Lord Hanningfield, you see. it accounts for the privilege. It mentions privilege. Now, in Southwark Crown Court, when the Lord Hanningfield was in front of the court, it's actually Jeremy Johnson QC at the time, KC, said that Lord Hanningfield couldn't be judged by a jury, although Magna Carta is not enforced anymore. Barons and lords can only be judged by their equals. But they said that his matter had the cognizance of Parliament because he was doing work for the House of Lords. But the thing is, what about incorrupt practices? You can be judged by justices in a High Court or in the Supreme Court, and possibly these special election petition courts, even if you are a peer, if you've got privilege. It says explicitly. But what happens is the person isn't allowed to use privilege as a protection from being put through the proceedings and actually judged, and they have to tell the truth and so forth. They can actually be judged, but if they're found guilty, the privilege actually protects them. And I think there's a certain process. You can check up on this just to make sure that I get this right. But you can't really lose your peerage, can you? The House of Lords can't have the period. You can't be removed. I don't think you might be able to remove someone from the House of Lords, but if you've got an appointment, like if you're a circuit judge or something like that, you get taken off it and so forth. Obviously, I think police. I don't know if the police can be prosecuted or not. This is a good question. But the thing with the law is that the law doesn't give police officers a privilege like the peers or House of Commons. For policing and the police, it's written so that the police officer, there's certain things he can do and certain things he can't do. He is breaking the law if he does certain things or other certain things not to the law. But how it's written, like for example, when he's doesn't have to observe the speed limit, there is no speed. He as long as he is as long as this is agreed that he is pursuing this case or criminals, then there is no exact. He's very, very, he's got a very, very great capacity for what he can do. Driving the vehicle, there is no speed limit. Effectively, any speed, So. But then when you get this reasonable force thing, what is reasonable force and what isn't? Well, so that means that you can be judged that it wasn't reasonable force. So then if he doesn't use reasonable, if it says that it wasn't reasonable force, it was unreasonable force, then that is an offence. So he's committing an offence on that occasion. Now, the thing with the police is in their casework, the unique thing with the police is when they're in, they've got like local circuit judges have got a commission to an area. So if you're a circuit judge for Leicestershire, you are only a judge in Leicestershire. You've got that commission, you're sworn in for that. So you're not it's not like, you can be a judge for all England because you only got a commission to be a judge for a certain jurisdiction. So it's not like, a judge from Leicestershire can be a judge in Scotland or Wales or in Cornwall or in London if they're only a judge for a specific commission for a circuit in a certain area. Now, I think that goes for the police as well when they're sworn in. That's why they've only got a certain jurisdiction. They're only policing a certain area. Now, the thing is with the police as well, they're trying cases to a magistrate's court, usually. They don't go to civil court or a crown court, but in a certain jurisdiction. So they're not actually petitioning Parliament on a national scale all around the country. And Parliament is a higher level. And legal issues and matters that are meant to be in connection with Parliament are supposed to be heard at High Court or Supreme Court or whatever, if at all. But the thing is, it is the jurisdiction of Parliament. They can have I think they can have their own. They've got their own committees and their own tribunals and so forth. But I think it can be dealt with a high. This is the thing. This is the question. This is the part that you see. The election petition is petitioning for election of, if it's a parliamentary election, not a local council one. We're using the model for parliamentary election, right? Because it's a petition for someone to be a member of Parliament. So it's a case to Parliament. But these aren't tried by Parliament, they're dealt with by the courts. But it's meant to be a High Court or equivalent jurisdiction. So this is why it has to have its own special procedure. Now, so that's the difference between a police officer and someone who's petitioning the King or a case to Parliament, because it's a higher level of authority of all England, and it's a higher casework. Now, the Tumultuous Petitioning Act 1661 does describe special procedures and legal proceedings for petitions to Parliament, either House, and the King. So it has got its own legal proceedings, like election petitions, but it doesn't describe any procedure rules or them in any great detail. It just sets out where they are and what. If you've got a small number of people, you don't require case management through the courts. It can be done by Parliament, which is the committees. Therefore, I'd say, because they had that. Yeah, they did have this committee of grievance, committee of griefs and petitions, motions of griefs and petitions, right? That's very important. So they have got a committee to deal with things. Obviously, if it's only 20 people, it's not too much of a problem. Then, obviously, if there's more than 20 people, then, the Committee of Motion Grievances can't deal with it. There's too many people. So this, you see, so you say, well, what about these legal procedures? Well, that's very interesting. Where are the equivalent of the election petition rules for the House of Commons petition rules? Where are they? That would be something, I haven't found them yet. Maybe they exist. This is what we're looking for. And I don't know anyone who's seen or found them yet. I don't know if you can have procedure rules, though, because if it's right since 1688, so either subject to petition the King, and all prosecutions and commitments for doing so are illegal. So they might not be able to hold you to commitments or procedure rules. Although the Petitions Committee has got standing orders, they are really the rules, really, and the committee has got powers for. The committee's got powers for compelling documents and summoning people. What for? Well, for the cases that you bring into them. What else? There's nothing else. There is nothing else. The powers, standing orders 145A3. There's some new ones now. Is it 159 or 158 or whatever? But they're the next ones. But I think the other ones, they're definitely required, or you can't function. What do they do? What does that committee do other than hear evidence for petitions that people submit? That's it, Now this is the problem. When Tony Blair created this online, you see, traditionally you submit petitions in paper anyway, in writing. Now, when Tony Blair and Gordon Brown, they made the first petition site, and what they're doing, you notice that they're messing up. There was this, it was just before that, actually. They had this Justices of the Peace Act, 1997, and it said that, if you're appealing for a resolution from either Houses of Parliament, you get an annulment pending resolution. Well, I think that would apply to any charges against you or prosecutions as well, which would be a working model for immunity as well as the matter that you're either bringing or it could be appealing. You see, you can petition about from local council. You can complain about something a local council's done. If you haven't got a resolution from that council, you can raise it higher. Just like through the courts, you can raise higher, right? So you're challenging their order, just like if you're appealing a conviction, but you're challenging or appealing a civil court order, but you can appeal a council order really as well. Now, the thing is that there wasn't really a proper requirement for how many signatures that you could get because they had a lower number. That's when people didn't really know too much about it. And then what's happened as it's got more popular and it's, people are using emails and the electronic digital technology is making it easier for people to collect signatures online, not in paper, then they've upped the requirement of signatures. Now, this is a fatal flaw of modern technology. What the ministers have done in Parliament is that they've thought that bringing a case to Parliament on the basis of number of signatures is far too easy. It's far too easy for people to do, and they want to make it hard for you. Not that, if they made a criminal case harder for the police to bring, then that would be something, or a civil case, No, they want to make it extremely difficult for you. So being greedy and wanting more and more and more signatures, like, we'll set an impossible task, right? They've stupidly and idiotically said that they're not even going to entertain it unless you get 10,000 to 100,000 signatures, right? Now, that is insane because what they're doing is quite contradictory and the opposite to the Tumultuous Petitioning Act. They're saying that we want you to get as many signatures as possible. In fact, insane, ridiculous numbers like hundreds of thousands before we debate it, right? And they don't have the Tumultuous Act procedure there. So they've taken away the special case management for petitions to Parliament, leaving it chaotically exploded around London, and now they're complaining that. And then what's happening then is Priti Patel is having to try to do something about it by criminalising the activities, attempting to make it criminal when it is one activity that you can't because you've got immunity and protection and you're meant to have case management for it. But instead, she tries to make all these laws up, which are actually prosecutable, which is insane, which is incompatible and contrary to law. And the Act is the Public Order Act. It even kind of insults the whole thing by using wording that even denies that you're even doing petitions to Parliament. It just calls it protesting. Well, why would you be protesting if you weren't supporting petitions, right? It almost creates this thing that she's not acknowledging that you are petitioning Parliament officially. She's acknowledging that there are people who are engaging in these activities called protesting and demonstration, and she's trying to pretend that they've got nothing to do with petitioning Parliament officially. So what are they then? She's trying to say that, well, they're political actions, but they're not political, or they're people messing around on the streets, but not official, right? But they scrap the requirement of their own case management, right? And there's far too many people for the petitions committee to manage it themselves because it's only a small committee. Now, if it is a small group of people, only 20, you don't need the case management. But then there's not insane numbers of people for one cause, right? One matter or one cause. Now, fair enough, you might say everyone can have their own cause and make their own petition up. But, they're even ironically. So, ironically, you know, if you've got a low number, if you've only got 20 people, if you've only got 20 people or whatever, you've not got that many people to manage. So it is enough for the petitions committee to manage it. But they don't even, they're not letting petitions in. They're heavily, people who honestly and truthfully submit legitimately petitions lawfully, and there are really no official procedure rules or anything that says what you can and can't petition about, really, only that it is fit to be received, which means that it has to be eligible and you can read it, and you know, you can read what people are asking, because people didn't used to be able to read or write. There was no compulsory education in the schools, or you didn't have to go to school and get an education. You couldn't even read or write or sign your name in some cases. You had to even you didn't need to get a lawyer to argue your case in court. You had to get someone who could read and write just to write it down. So that's how fit they are to be received, and how far they are to be received, well, is what would have been decided by these tumultuous petitioning act procedures if they were to be received, you know, as far as Parliament, if there was over 20 people or whatever, you know, large numbers of people, and casework went through that management, right? So, in a way, but the thing is, the petition, the signatures, they are only to statements, basically. Statements and witness signatures and support. All it is to show evidence that it matters to a large number of people, or that they witnessed something to prove a fact. Because really, the petition is just a legal case like any civil or criminal case. It's based on, you see, if you're trying, look at this actual act here that is election petition rules, right? You're trying, you're meant to do this afterwards, right? If you want to challenge if it was run legitimately or not, and if it was corrupt, like if a certain person has or has not been elected, or if someone else really won the election because of cheating and so forth, the judges decide. But that's after it. It's looking like, I haven't read all of this, but I'm reading it now, and it seems like it's done afterwards to find out whether it was legitimate or if there's any cheating. I think they finds out exactly what went wrong and what was wrong in it, and obviously I think therefore you're intellectually calculating, you know, who should have won, basically, according to the facts and circumstances. I don't think they redo it. I think what they do is they establish what went wrong, what was done wrong, and therefore calculated from that who really won. And two judges have to decide from the parts that I've read, and both have to agree with each other, so forth. So the thing with the petitions to Parliament means that really, because this election petition is judged kind of afterwards to see if it was legitimate and who's at fault, I think that's the case with the petitions to House of Commons. I think you have got your immunity, and then obviously when the case gets a resolution or decided or judged, I guess when you've collected the signatures or the evidence or whatever, then obviously the whole thing gets meant to get tried together. Or if you've got this case management, if it's a large number of people, I think they want to know what you're doing and what you're planning, and you know what you're going to be doing and so forth. Now the thing, then you see you're actually acknowledging that this thing exists. You see, the problem with Extinction Rebellion cases, for example, at the moment, is they're going into a court, but it's not even getting acknowledged that they're doing petitioning and that it is a special thing. In some of the cases, then it never arises. The CPS or police are just throwing these criminal damage charges at it. Oh, this is a woman, she did this, she did that, she's a criminal, as if the political element does not exist. some of these Extinction Rebellion people are like starting to talk about, their case and the petition case and why they're doing it and so forth. Well, I said that's irrelevant because you're trying to establish whether they've got petitioning and that, the thing is, there's a Town and Country Planning Act, 2 of them, and it sets out a lot of regulations for all the use of notices, banners, signs, painting, all that, and it gives consent and so forth if it's a certain class because it's for a certain purpose. Now that is part of the legislation for case management of petitioning because that's what you're using, and effectively it just gives you pretty much immunity because what it does is it effectively disregards the statutory instrument that everyone else has to comply with. You don't effectively, right? Close enough. Practically, you're exempt from the instrument. So that's effectively, it's annulling the instrument, really, or close to Class F. Near enough completely annuls the instrument. Everyone else who has to abide by that instrument when they're putting up material, commercial material, and getting fined, and can you and can't you, and where can you and can't you, and all that, it effectively, I might as well, near enough, depending on which act of law you use, because you can, he's saying if you use of enactment. So that really, if you are intelligent and if you use common sense and if you just fact that you're saying the same thing in a different way. With what it's doing is it's describing essentially the exact same legal basis using slightly different words than that Justice of the Peace Act 1997, which says, if you're pursuing a resolution for the House of Commons, then it's subject to annulment or criminal instruments and procedure rules, because you can't be prosecuted, right? But you're pursuing an annulment to the House of Commons. So they're going to be looking at the matters, right? Not, the place, if it's a local council or if it's just a matter you're bringing to them, right? It won't be another court in a local jurisdiction or whatever, because you'll take it to Parliament. Now, the thing is, are the Parliament Petitions Committee going, look at the instances of, what you have and haven't done, or are they going to put it to a court like with these election petition rules? Now, but the thing with these election petition rules is they've got these bases, right? And the basis is, I think, that, well, firstly, right, there are lots of people engaged in the election because there's loads of people voting, right? It's like if you're petitioning either Houses of Commons, you've got a lot of people signing the petitions. If you're doing an election, you've got a lot of people voting. Some of those people might not be eligible to vote, or might be voting illegally, or might not be British citizens, or might have been doing illegal corrupt practices with, aiding, illegal canvassing with the candidate or like, Rees Mogg and GB News type stuff that we're arguing about now and stuff, things like that. So you have got a large number of people, but who can and can't be prosecuted, it changes over time. They start introducing certain punishments, but at this point when we're reading this law here, they're going on the basis of immunity. But the thing is, you can't use privilege, like for the House of Lords or Commons, to get out of proceedings and being prosecuted. You have to answer questions. Now, this is the thing. I think Jeremy Johnson KC did say to the court that they could have heard Lord Hanningfield's case. He did this kind of like double Dutch language, this kind of like, poet laureate, etiquette kind of like backslap thing where he's like, oh, well, you're perfectly entitled to hear Lord Hanningfield's case, but, blah, 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 blah. effectively, he said, but he's protected by the House of Lords, whatever, got cognizance of the matter or whatever. But I don't think that's necessarily true, because that would mean that Lord Henfield wouldn't have to answer questions in one of these election petitions if he were under scrutiny in it, involving some corrupt practices. That means that he'd have to be heard by the House of Lords. But in this, it says that it's got to be held in these special petition processes, and they do answer questions, but I don't think they're liable to be convicted and imprisoned. I think that it's just that you can be convicted but protected from punishment. The privilege, it says in this, doesn't protect them from having to answer questions honestly and truthfully. What the basis of all this is that effectively, if you tell the truth and are honest, then you are protected from conviction, imprisonment, and prosecution. But if you don't tell the truth, you're kind of forfeiting your immunity, I think. So I'm not sure. But I don't. But it as a witness, if you appear as a witness, and the thing is, in a criminal or civil case, the plaintiff, the claimant, is usually or always a witness, because they're bringing a case against another person, and that is the case that is in scrutiny. And if they tell the truth, they've got the certificate of indemnity, which protects them, right? But you see, if you're a justice or a judge, I think, or like, I was going to say maybe police, but I'm not necessarily sure if it does, because we've only got a jurisdiction in a local area, and like judges and so forth, apparently it seems like they've got immunity, but I don't know where they get that immunity from. Because it's definitely not Magna Carta. They're not barons or lords, and it's not the cognizance of Parliament, is it? So I'm scratching my. I'd like to see where. Well, it might be in the Justice of the Peace Act to check it out. Once you made a judge, this is always engaged in their job in casework all the time, So, but if you are, as far as I gather, if you're a witness, if you're trying a case, including the right to, effectively the right to petition, the 1688 Bill of Rights, when they introduced the right to petition, they're making it so anyone who is basically a witness bringing a case, and witnesses have got immunity protection as long as you tell the truth and you're honest, basically, and that effectively is equivalent of what justices have got, really, but only for that case, like your certificate of indemnity sort of thing, not for the your entire job you're doing all the time, or like peers in the House of Lords. Now, so this here, but so there's a little bit of I'm a little bit uncertain between when you go from the committee to the High Court, because in the Inquiries Act, they can deal with certain matters, but they refer criminal matters or something that needs an order made to the court, but they deal with the investigative part of it. I'm starting to think, therefore, it seems like, to me, the parliamentary committees, House of Commons committees, I see it now like the Inquiries Act sort of thing, how they're operating in the Inquiries Act, but like a little version of it, like a small version, because it's like the committees in the House of Commons don't have the capacity to deal with things like that, which is really therefore the entire point of the Inquiries Act. It's to focus on one matter with a greater capacity. Otherwise, the House of Commons committees don't have the capacity. But that's it, effectively. They're just creating a little, not a little, they're creating a specialist, they're appointing someone to deal with something with a greater capacity, basically, just for that matter, and then it's dissolved, basically. So, but they still refer things to the courts. But traditionally, I would have thought that, why don't they deal with it in the House of Lords if they've got judicial capacity? And that, you see, this is when you get... So therefore, the mystery part of that, to me, is then what is, the Painted Chamber, with, Brooke, Essex, Bedford, and Warwick, dealing with, misbehaving judges and justices. Well, I think that Painted Chamber Committee in the 1640s was effectively basically like the Judicial Conduct Investigations Office, but rather than having an office of investigation in the Royal Courts of Justice chaired by the Lord Chief Justice, they had a committee dealing with it in Parliament, which had various members of the House of Lords and possibly some MPs in there as well, a committee. And obviously the Lords on there would deal with the judicial matters, I would have thought, kind of a little bit like Privy Council sort of thing. Maybe they did refer things to the courts. But what's the point of having the House of Lords in if they've got judicial authority and capacity? Because you've got this Appeal Jurisdiction Act where you can appeal matters to the Lords. So I don't even like the idea of the Supreme Court, really. If you're petitioning Parliament, why isn't it dealt with Parliament, even criminal matters? But we've got the High Court and Supreme Court anyway, so it doesn't matter too much. But what's for certain is it's not the County Court, and it isn't the Central Criminal Court, and it's not the Assizes or the Quarter Sessions, and it's not the Magistrates Court either. But they had proceedings. If it's they were sort of they were doing case management. But then there's also the question: well, were they doing case management for petitions to the local council about local matters? And were the ones to Parliament getting referred to the House of Commons and to Parliament, and therefore that wasn't under those low jurisdiction courts? That's the thing. And another thing that I need to say at this point as well is that I need to say that when you search the current criminal procedure rule, so when you search the criminal procedure rules, there's a 2005 ones, and I think there's I've got them on my phone actually. I was just looking at them. But when you search the criminal procedure rules for words and terms like privilege, it's not in there, or indemnity, like certificate of indemnity, it's not in there, or even the word petition is not in there. It's not in the criminal procedure rules. Nowhere in the criminal procedure rules does it feature the word privilege, indemnity, or petition. Okay? Now, that means that the Crown Prosecution Service, if they are only looking at the criminal procedure rules, they're not going to see anything in there which is going to guide or direct them about, Extinction Rebellion or anyone like that who are getting prosecuted by the police. Now, when you search the civil procedure rules, there is the word indemnity appears, and there is the word privilege appears, right? But the definitions and terminology are slightly different in context to in these election petition rules, but it does acknowledge them. Now, the thing is, when I was in when I was at a hearing for my criminal case, I entered a claim of petition right for the immunity. And what happened is they brought into the civil procedure rules for me to make that case, which I had a chance to, but that wasn't under the criminal procedure rules anymore. And the prosecutor wasn't there. And it would have been possible for me to prove it. But you're not using the criminal procedure rules there. You've got it in civil. Right? Now, this is the thing. Why does it not feature in the criminal procedure rules? Is because, well, you can't be criminally prosecuted. But the matter needs to be looked at and dealt with. So, all these tumultuous petitioning act and these election petition rules that we're looking at now are really it falls under civil procedure in the High Court. Well, High Court can deal with either. And the thing is, they're trying to establish facts and decide a case on a matter like, whether an election was run correctly or properly or not. And you can actually have these convictions but not suffer a criminal prosecution, but there can still be certain types of penalties or things that need to be dealt with. But it's not really, you see, I think that tumultuous petitioning act, therefore, it's kind of like, you see, the High Court deals with both criminal and civil matters if necessary. But when you're in a criminal proceeding, well, you can raise civil matters in criminal procedure. The thing is, the prosecutor is meant to be. The thing is, with these election petition rules, there is a prosecutor, and I read that the prosecutor is meant to be present if there's any other matters being raised. And in mine, there was no prosecutor present. They didn't turn up for my civil hearing. Not that I don't think it could have been heard in that magistrate's court anyway, because it's under the jurisdiction of Parliament. It's supposed to be the High Court. Well, it's actually you're meant to have your own thing, your own proceedings. But so you're not going to find the police and the CPS will not find anything in the criminal procedure rules. But ironically, the criminal procedure rules. What about this? What about the Crown Prosecution Service and their entire page on assisting offenders? Assisting offenders. They call it assisting offenders, and they get the Chief Crown Prosecutor and the Attorney General to agree to grant immunity to witnesses, which effectively is one of those certificates of indemnity, really, but that's in criminal proceedings. But I don't find it in the criminal procedure rules. We'll search it in a minute. Actually, we'll search the criminal procedure rules for the words and term assisting offenders, and I bet you it doesn't come up with any results. Well, I think the word offender will be in there, but not in. I don't think it will be assisting. I don't think you'll find the word assisting in there. Which makes you question, well, why the Crown Prosecution Service got an entire page on assisting offenders, but if there's not anything in the criminal procedure rules specifically about it? Well, I don't think it's in the Act. It might be in the Magistrates Court Act or another Act, or it's just something that they do, that they know of, but isn't in those procedures. But we'll look at that in a minute. Because the thing is, what they're doing is they are the one bringing a case against you, and they are getting witnesses to help them and giving them a certificate of indemnity, which is what is going on here when you have witnesses in an election petition. But so why doesn't the word certificate of indemnity appear in the criminal procedure rules? Well, because it's not called a certificate of indemnity, obviously, by the CPS, but effectively that's what their page on assisting offenders is. Granting immunity is a certificate of indemnity. So why isn't it in the criminal procedure rules? Well, that's a good question that we'll look at in a minute. Now, I've had this page up here the whole time through. And so why have I got this page up, and why have I been talking all this time, and I've only just got around to explaining this page here? Well, this now is the part that what I would say this is someone writing election petition rules, and they know what they're talking about. They're doing it in 1880... 3 and 1895, and the person who's writing it knows about the Tumultuous Petitioning Act, knows about the existence of people petitioning either of houses of Parliament as well, and what the right to petition is in the 1688 Bill of Rights, and understands the legal basis around it. And as this is extremely similar, it's not a petition to the House of Commons, but it's an election petition to the House of Commons. So it's the closest thing you can get. It's closer than criminal procedure rules. It's closer than civil procedure rules. It's the closest. It's close. It's closer. It's as close as you can get without being the Tumultuous Petitioning Act or the 1688 Bill of Rights right to petition, because I don't think that there is much else, right? It's closer. It's establishing that the criminal procedure rules are not the ones to use. That's for sure. So, and it also, what you're doing when you write a petition, when you even pick up a pen to petition either of Houses of Parliament for a House of Commons petition or to the Lords, which is what we're talking about with the 1688 Bill of Rights and through the Tumultuous Petitioning Act, what do you even do how do you do that? How do you start it? Because all we've got at the moment that is, like Parliament have got a page where you can create one on their website, right? But they're making it quite simple. And these things it's a case, so it can be judged on facts and facts and evidence, or number of people signing it. But your people signing it are only your witnesses. The thing is, back then they didn't have cameras, video cameras, anything like that. It all went on witness statements, writing, descriptions. You didn't have cameras. Maybe you could have an artist or something to draw a picture. But therefore, I mean, if 50 people in a village had it ransacked by soldiers, then how do you know? Well, because 50 people in the village write statements, then you got 50 statements, right? And then, then you've got your own evidence and statement. It's all in writing. You might have exhibits. You might actually have exhibits. You might have a broken teapot or something or whatever. This is the thing. But if you have filmed 20 people in the town writing, then you can watch them all on the video camera. Although this is the argument at the moment with the police. They just want to film everything and say that happened, that's a fact. Now, it's not innocent until proved guilty. They effectively want you to go into court and, you'll have to try and prove you're innocent. They've already, as far as the police is concerned, they filmed you doing it, and they think that you've done it, you're guilty, and effectively they're even wanting you to confess and pay the fine without even going to court. That's what the police are doing now. They just want to film you, confess, and then get the punishment. There is no fair trial. There is no forgiveness by the jury, and that's what forgiveness is figured in by judgment of peers or by rule of law, which I don't think the police chief can get his head around, because police are almost like a little pit bull terrier, once it decides to bite, won't let his teeth go because, well, he's oath's charged with, upholding the law, so he's got to follow it through. That's why they don't like doing it, because then they're, not doing their job, but they don't like admitting when they themselves haven't done the job properly, which is where the problems arise, corrupt practices, which is what this act is about. But anyway, so we'll just read this now, and because this is why I wanted to show you this. So first then, as to the drafting of the petition, well, that's what we do when we actually petition in either House of the Commons. Every election petition will be sufficient if made in the following form, on or to the like effect. Well, when you petition the House of Commons, right, it will be sufficient if drafted in a certain way. Well, all they do is they get you to basically fill your details in very simply, name, email, postcode, and then put a title to it, and then draft it out. They even restrict your characters, but they don't restrict the number of people to sign it because they want you to get a lot. In fact, they won't even let you run it. How fit and far is it to go? But they don't get a grand jury, best part of a grand jury to judge it. It's always the petitions committee, which is kind of unfair, really, because apparently you can be judged, by rule of law or your peers. And if it's under 20 people, you're not going to pose a threat to anyone, are you? But then again, they're running some very, very, very large petitions on that website, but then they don't like it when there's loads of people turn up supporting it outside Parliament, kicking off, and Patel's having to make new legislation up, which really, when they've actually let it be published and then it's officially on there, and these people are signing it, Patel really is kind of like conceded on the legislation she just wrote, because as long as the people are telling the truth and not lying, they've got, in a way, really, they're all witnesses, which is unfortunate for Priti Patel, really. That's not my problem, that's her problem. So in the High Court of Justice, King's Bench Division, well, that would say, on the petition to Parliament, it would say in the House of Commons, right? It would say in the House of Commons, in the Petitions Committee. Election for state the place holder. Well, that would be the title of your petition here. So you put your title of your petition there, because you fill it in there, whatever. Name the place. Well, in a county, is it? It's meant to be in Parliament of the jurisdiction of all England. The petition of A of, or A of, and R of, as the case may be. So it is a case. It is a case, as the case may be. So even a petition for an election is you're bringing a case whose names are subscribed. Well, the names are subscribed when you get them all to sign it, surely. Now, there might be an argument here with Parliament and the courts that the person who starts it is the name who's subscribed, not the people just who sign it and give evidence. But it's in the Inquiries Act. It says A, based on evidence, or B, based on the evidence of public support. So I can't see how, even if you're the person who drafts it, the petition of, right, but all the people who sign it is evident. It's evidence. So it is evidence of public concern. So the other people who sign it, not the person who drafts it, the people who sign it are witnesses, because they're giving evidence. They're giving evidence of public concern. So they are being called as witnesses. There's no doubt about it. They are being called as witnesses, and Parliament wouldn't. Parliament are making you call 100,000 witnesses on the matter before they debate it in Parliament. So, because in the Inquiries Act it says that the case is judged on evidence or evidence of public concern. Well, if Parliament and if those 100,000 signatures isn't the evidence of public concern, I don't know what is, right? Because you can't, and if they're going to judge it based on purely on strength of the case, on the evidence that you've collected, they're not really giving you much opportunity to write strong evidence when they're only restricting it to 50 words or whatever in the petition, or however many. And when you put links to evidence, they always come up with always coming out with ridiculous excuses like, oh, you're linking to frivolous or fraudulent evidence. Well, they've said that on a number of occasions when I've actually just linked to the government website. Like the government website. Now, the stupid and ironic thing about the Petitions Committee in Parliament at the moment is, in the petition, you can put a link and it does work. When you do the petition and put a link, it highlights it with a hyperlink, so they've programmed it to accept links. Now, if they are exercising discrimination with, Dr. Tess Lowry, so, academics and professionals, they'll allow it to, but not, us. I've never in my whole life known a criminal case where you're not allowed to submit evidence or try the evidence, not even attach it. They won't even let you attach it. I mean, I've had it attached and I've submitted it and the judge has read it and he said it's a load of rubbish, but I've never had him say, I refuse to, he's refused to let you submit it. And I don't think the Petitioners Committee themselves are even, but I mean, it's just that they don't want to have the links on there off-site, but the evidence is for the public to look at in your case and see whether they think that it's true or not, like the judgment of the peers based on fact of law or the opinion of the peers, regardless of whether of what the truth is. And that's where I think the Petitions Committee are breaking the law, because they're trying to do basically what they were trying to do on Facebook anyway and YouTube, which is try and censor information and people, what they say is true or not. And a lot of the things that Parliament do aren't even legitimate and lawful anyway. It is criminal. It's a corrupt practice. What they're doing is it's perverting the course of justice, and it's an abusive process. That's for certain. You can't link to the Oxford Dictionary for the definition of the word corrupt, and then Parliament say, "Oh, you're linking to frivolous or defamatory information." No, it's a fact. And what happens if you put that evidence to? What if it's evidence that we want to get the law changed on the regulation of websites because we think websites, are putting false information. So you'd have to attach evidence to show that false evidence was being given, but then they would disallow it or try and reject it on the basis that it wasn't true. But you're attaching it to prove that something isn't true. Right? So how does Martin Day MP calculate that one? So I want to petition the government to change the laws, right, on, online website regulations because, they're showing false evidence. So I need to attach evidence that there is false evidence. But then Martin Day MP is going to say, oh, you're attaching false and frivolous evidence. It's not the truth. But yeah, Martin, I'm attaching it to prove that something's not true, right? There is a clear marked retardedness in these ministers. I think it's stubborn. I think that it is a corrupt practice. I think that it's party political. Like you've got these Labour MPs and Tory MPs. I think that they are playing goalkeeper, trying to keep things out when you're opposing them lawfully and fairly. I think it's a foul. I think that it is, well, it's perverting the course of justice because it is this is a process of law, and they're perverting it, and they're just making things up. The standards don't exist in any standing order, statute, law, or codified law or act. There are no standards for evidence because you're trying the evidence, and who is to evaluate the evidence? This is the thing. Well, in a court, the jury decide whether a statement's true or false. All you do is you have to make the oath that you believe that it is the truth. You believe it to be the truth, right? And you call your professional witnesses. Now, if they want to disallow a witness or whatever, but the thing with Parliament is, what the MPs don't like is that you've got to collect the evidence, and when you obtain it from the public's signature, the public have a right in that case to you can't get evidence of public concern unless the public have a look at the thing that they need to know whether they're concerned about it or not, right? And they have to be judged what they think, like in a courtroom. If those 11 committee members are behaving like judges and disallowing or allowing certain things, then where's the rest of the actions that we want from them, like enforcement, where the subpoena powers, where is the compelling documents, you can't have that document, that's false. Well, what documents can I have then? Why don't you compel some, the problem is that compared to a normal court, we've got these political parties, and that's why there's meant to be so many members of the committee from so many different parties. But I can't see how you can have a fair judicial process that is based on political parties, particularly if you're coming independently, because it's always going to be tainted by those parties. And that's why I don't like this whole control of the council business. And what we've come to see now is that when they do a public consultation, they're actually asking everyone, including the people who elected the councillors, they're asking them for their opinion on one point. Not on all of the, general things that they elected their councillor to represent them for. They're asking them to give their specific opinion on a specific point. And if they choose not to give it, then clearly it's got to be regarded as that they don't have an opinion on it. Not just that, we always support every Labour Party policy all the time, because not all Labour people do support every Labour Party policy all the time. And when they've gone out of their way to ask this question on one point, and they choose not to give an answer, it must mean that they don't have an opinion on it. So therefore, the public consultation in the council, that has to be the opinion of everyone. They ask them. So if they aren't going to act on that, who are they acting on? This is why I've said that, how can a local councillor vote in a decision whereby they've asked everyone, whoever, who shall now speak now or forever hold your peace, this is it. The consultation surely is the opinion of everyone. So, you cannot disregard it, because that you've asked people to enter judgment. And councillors act selflessly in their voting. Apparently, they're not voting for themselves. So it cannot be legally possible. It is a legal flaw from Magna Carta, because if you disregard that public consultation, you can't cast votes. The councillors can't cast votes because the votes can't be themselves. They're selfless. They've got a policy of selflessness. So there is no power to cast a vote once you disregard the consultation. You've effectively you've annulled your power to cast a vote in the council, surely. So who are the committee? And surely that basis has to be in the committee as well. Surely that basis has to be the basis in the petitions committee, And if they're disregarding people's opinion, how can they make... if the petitions committee... Are the petitions committee meant to be selfless? Are the petitions committee... Are MPs meant to be selfless like councillors? And if they are... how can the 100,000 people judge the evidence and tell the 11 committee members whether they think the evidence is true or not? This is the thing. Anyway, let's get back to this document. So this is basically the people signing it are definitely giving evidence. For sure, they have to be. It's evidence of public concern. So they're witnesses. They're giving witness evidence. So I'm quite certain that your signatories are in. And I don't know how this plays out in the election petition for people who vote, who cast a vote, because surely that is evidence that someone's been elected. But if they cheat it's different if they cheat the process, Interestingly, though, they don't have a jury in this election petition process. They have 2 judges. So that's interesting, because then it's not getting judged by the people, it's getting judged by judges. But in Parliament, MPs are meant to make decisions supposedly based on the electorate, which is kind of... I'm not a great fan of these judges anyway, these justices, particularly in light of Magna Carta, and the fact that we've kind of ditched and dropped juries in a lot of civil matters and proceedings that usually don't even need to go. You see, a lot of matters that are resolved in courts, even by juries, like particularly in the Crown Court, and that's it. It's done. It's done with. You're only raising matters up higher with this. But apparently you can seek a resolution to either Houses of Commons. But can you seek a resolution to the House of Commons from something you didn't like in the High Court or something you didn't like in the Supreme Court? And apparently an impeachment by the House of Commons cannot be pardoned, right? So that's interesting, because that means that if you did get prosecuted, the House of Commons are saying they don't deal with criminal matters, but if you did, then I don't think... It says an impeachment by the House of Commons cannot be pardoned. So does that mean that it can't be pardoned by the House of Lords or the Supreme Court either? Does that mean that, you're at the highest jurisdiction? And that was before they got rid of the Appeal Act Jurisdiction Act. I've got a feeling that it's regarded as one thing. Like, like when you put law through, when you get legislation put through, it goes through the House of Commons and then gets passed by the House of Lords. I've got a feeling that that's what it means in the 1700 Act of Settlement. I've got a feeling that it says an impeachment by the House of Commons cannot be pardoned because, it gets put through both houses like as one motion. That's my gut feeling on it. The petition of A and of B, as the case may be. Well, that's it. Depends what the case is, doesn't it? Depends what case you bring in, or what matter, or what cause, whose names are subscribed. Well, it depends. Like in the Tumultuous Petitioning Act, you might only have 20 names, or you might have 100, or you might have 100,000. Your petitioner A is a person who voted or had a right to vote, as the case may be. Well, that's, you can understand and read that as a bit of a homage and a gesture to the fact that, when you're petitioning either houses of Parliament, you use the right to petition, you using the right of the subjects to petition the King, and all prosecutions and commitments for doing so are illegal, which definitely is reflected in the Town and Country Planning Act statutory instruments, because effectively, if you're using that enactment, it's annulling that instrument, which is exactly the same as really in the Justice of the Peace Act 1997, which says that appealing to either houses of Parliament is subject to annulment of an instrument. The right to vote, as the case may be, at the above election, or claims to have had a right to be returned at the above election, or was a candidate at the above election, and your petitioner be here state the like manner the right of each petitioner. Maybe the House of Commons are tricking us at the moment with their dumb form and not putting all the full criteria in there. Maybe but usually all court forms require you to put the statement of truth in at the end, and it automatically puts it there, and you just tick the box. They already do that. Professional court forms, it has all this, I claim that this is the truth, blah 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 blah, statement of truth, and all the legislation and rights that are in force for you to be able to do it and have to do it are there, but apparently not so on the Petitions Committee website. Once you do it in writing, submit it in writing. This is meant to be the work, that's meant to be the area of contractors who write contracts, or, power of attorney, or writing a will and all that. You're meant to go to a professional who drafts it up properly so it's all legal and proper. Which seems the House of Commons, maybe they could do with using some of our tax money to get, some power of attorney or some will. Maybe Jeremy Johnson KC should draft it or write it. Wouldn't that be something, Maybe the House of Commons could employ Jeremy Johnson KC with our taxpayer money. Maybe he could help redesign the Parliament Petitions Committee website and make sure it does have the correct appropriate legal statements in place, declarations, rather than just postcode, email and name. That would be something, and should they desire and have the will to do that, is it an abusive process not to include these statements? Is it preventing the course of justice to fail to have the correct and appropriate required statements and declarations on the legal form that you submit to the Petitions Committee? That would be a question for Jeremy Johnson KC, possibly more important than. So yeah, it's so right when Lord Hanningfield's facing charges, they're quick to call in Mr. Johnson KC then, or if the Mr. Assange is requiring assistance, but not when the entire nation, the entire full 60 million or whatever, probably nearly 70 million now, I would have thought, about immigration, the subjects of the realm are not entitled to afford, on the taxpayers' expense, the services of Mr. Jeremy Johnson KC to ascertain the professional and complete legally required declarations are in force and in place on the petition website, even though apparently we can't be held to any commitments anyway, so maybe we don't need them or have to have them. But then does that mean that is invalidating them? But is that an abusive process? Do you need them or not? And if you had them in place, then would the Petitions Committee be able to reject them? Because really, if the Petitions Committee have got, like, if you put, this is the truth and fact, to the best of my knowledge and of the witnesses, then how can they reject it? Because you put a statement of truth on it, and you're presenting it as this is the truth. That's my evidence. And I subscribe that it's the truth. Maybe that's how they're able to reject it. But then, aren't they abusing their own process? These are things that are quite serious. These are things that should be in front of these, privileges committees. But then again, you'll get the standards of, Ofcom, the Digital Media, Culture and Sport Committee that is looking at the case to do with Rees-Mogg as well, included in it. And they are definitely, I've got a complaint about that committee, how they're dealing with it. I think it's generally MPs. I think that they kind of like, in a way, they're not quite competent enough, and there's a little bit of incompetence and a little bit of defiance, a little bit of corruption. They want it to be the way they want it, and they want it to go the way that they want it to go, and they think they're in complete control, but they end up, in order to get their way, they have to bend the rules, or even break them, or ignore or disregard them, and then they're becoming corrupt, and they don't quite realise that, I think they think they can get away with it, and they just don't quite realise that they're breaking the law, and it's corrupt, and you don't do that. And they do know enough to know that they need to not tell you certain things and cover things up. But if they knew a little bit more than they did, then they would definitely know that that's a bad idea and they shouldn't do that. And they can't do it. And that's the difference. So it's almost kind of like a handicap which causes havoc, but they know that they're doing wrong. Maybe it's maybe their shortcomings in intelligence is their moral shortcomings as well. Maybe their intellectual shortcomings is somehow partly their moral shortcomings as well. Not quite intelligent and not quite of the integrity. They're not quite intelligent enough, and they don't quite have the moral integrity of honesty and truth. So therefore, that's where they fail, really. Which means that you don't want these people elected anyway. You want people who do have the intelligence and integrity for Parliament. But then again, I think you've got to have a sandwich shop of picnic to stand up there. You've got to have big testicles, because people who do have, I don't think people who do have the intelligence and do have the moral integrity want that job, because it's like Johnson. It's like Boris Johnson's the model, really. It's an idiot's job, really. It's or you've got Mogg, who thinks that he's smart, but really he's not. It's either for like Penfolds, who think they're cleverer than everyone else, but they're not, or show-offs like Johnson, who really shouldn't be there, and they're just showing off. Although no one would presume that Johnson thinks that he's cleverer than anyone else, like Mogg does. He's just reckless people. Your petition, the person who voted for claims to have the right to reach petition. A new petitioner state that the election was held on the day of ABCDEF with candidates. Oh, right, candidates Your petitioner state that the election was holden on the day of when A, B, C, and F were candidates. The petition of A and of B, as the case may be, whose names are subscribed. Your petition was... Candidates and the returning officer has returned A, B, and C and D has been duly elected. Well, you're not actually in a petition. Well, you can actually have a grievance. The thing is, you can actually have a grievance. Again, a grievance against something that has been done wrong surely has to be been done wrong by someone. If it's government, depends what the case is about, doesn't it? You can have a civil case where you want to challenge a point of law, or you can have a civil case where someone owes you some money. Or you can just have a civil case where, you want to prove that, clarify the law. Like in America, they've got this federal question proceedings. And your petitioners say here that the facts and grounds on which the petitions rely, your petitioners pray that it may be determined that the said A and B was not duly elected or returned, and that the petition was void, that the said E and F was duly elected and ought to have been returned, as the case may be. In the case of an election petition under the Acts of 1883, and the names of these acts should be added to the title of the petition, and the blank is paragraph, and the body of the succeeding paragraphs may be filled in as follows. Must done is according to the number of offences or matters which is desired to state. All right. So you're actually accusing someone of breaking the law, the Corrupt Practices Act, for petitioning. So it's like an affidavit as well. It's like a proper petition of affidavit, this, with witnesses and candidates. A petition in this form is more advisable than a petition vaguely. A petition in this form is more advisable than a petition vaguely alleging corrupt and illegal practices. So you can have, it doesn't actually have to be in this prescribed manner, which is basically what I just effectively was like gesturing to with, we could do with getting Jeremy Johnson KC to draft it up. It doesn't have to be. It's just more advisable than a petition vaguely alleging corrupt and legal practices, because immediate particulars of such petition would be ordered, whereas if a petition were in such forms as that which follows, particulars would not be ordered till within 7 or 10 days of the trial, which the practice is great advantage. Wow. That is something. That is something indeed. Well, I would suggest, clearly then, on the HM government petition online web form, wouldn't you say that a petition in writing to the government, if you writ your own, like expertly drafted, would be a lot more advisable than what they're offering online on the green form, with just putting your email, name, and postcode, and then having a title, and then whatever 50 character limit or whatever. Even though it's designed to accept hyperlinks and activate them, but they rarely they rarely allow or publish them with such live hyperlinks. Ironically, oh look, you can have the hyperlink, but we're not going to give you it. But it would be much more advisable, even though you can actually appeal those petitions, but they always say that you've got to resubmit and try again. But that's not appealing it. Appealing it is to appeal the one you submitted. You're not appealing it when you resubmit it. You're actually trying again. That's not appealing the one you submitted. But then you've got to collect your 5 signatures over and over again. So they're actually, there is actually a listed appeal process as well, and then they're actually misleading you about the appeal process. That's another complaint against the Petitions Committee I've got to put in. They're actually, there is a published appeal process that you can appeal in the guidance, and they're not telling you. What they're doing is when they reject it, they say you can't have that, and you'll have to rewrite it or try again. And that means you've got to recollect your 5 signatures. That's not appealing it. That's actually trying another case. It's retrying it. It's not actually appealing the one that you submitted. So that's another legal fallacy, corrupt practice of the Petitions Committee. Definitely more advisable to write it in person, but then again, you've got to collect your signatures on paper, 100,000 of them, and you can't really share it by email. So it's much more advisable to the strength of evidence, but less advisable to the public for sharing, because then you've got to get it all printed up and use printer and ink and walk around the streets or whatever, pay for postman. So it's not as advisable to the public as electronically, but then they're not letting you advise in the evidence online. They're not letting you advise in links and evidence because they're heavily restricting the strength of your case. This is vaguely alleging corrupt and illegal practices because immediate particular such petitions will be ordered, whereas the petition where such forms as follows particulars would not be ordered till within some days. Created below. The Lancaster Division case is preferred petition as to which we are about to set out that the said A, B, C, and D by themselves, their election agent, and their agents before, during, and after the above election were guilty of the corrupt practice. See, this is like you're getting onto Rees-Mogg territory now, because for his election, it's almost like he's getting paid by GB News a wage from private money, which is kind of helping his popularity for his own campaign, clearly. And it's not coming from his election agent, that's for sure. And that is where it's illegal canvassing. If he appears on the news as a member of Parliament to be questioned, he doesn't receive any money for that. He's not receiving money. And he's not making a personal gain out of it. He's not making a personal money gain out of something of which he's also gaining an electoral advantage out of at the same time. You see, the thing with being paid by GB News is that he is himself making a personal profit himself, which is taxable, and there's tax involved out of something which is aiding his candidacy and advocacy popularity. And the sometimes there's an argument to say, well, is it 50, is he only getting a small amount or any amount? Well, I don't think you can have any. I don't think you can have any, because I don't think that you're allowed to be employed, and that's the point. You might say that the amount of money he's getting a very small amount of electoral advocacy, but I don't think so. If you becoming a household name and for getting familiarising with your country, how much is an election worth? How much would you buy if you could buy a place in Parliament? If it was worth money, what would it be worth? If you didn't get elected into Parliament, if you bought it, how much would it cost? £1 million? Is it worth to someone, for an entire term in Parliament or something? More than what Rees-Mogg's getting paid for his wage on GB News. This is the difference, you see, between Mog's doing and sort of what Reclaim the Media and Tice and Galloway are kind of like nibbling at the edges of it, and have they nibbled too much? Are they just coming on as guests, invited on, or is their channel sponsored by their campaign and paid for by their campaign, non-tax, non-profit? You see, Mog, while promoting himself and gaining electoral advantage, must be for non-profit, but he's profiting out of it and paying tax as well. So I just, however you want to approach it, I do not believe that Mog is lawfully on GB News, and the arguments about cabinet, not cabinet, have got absolutely nothing to do with it. He's got a position that he obtained through an election, and he's there on merit of an election, and he's there on merit of electoral success and popularity, whether he's coming in or going out or coming in back again or not. The seat is not to be claimed. The seat is not to be claimed in a petition under the Acts of 1883 and 18 unless enough votes had thereunder to turn the scale can be proved. Well, that's interesting, because the right of petition, how can you claim the right to petition? You have to be doing a petition, but you don't have to prove the case or claim it, do you? The police don't have to win a case. The police don't have to win a case in court, right, in order to have the right to pursue the criminal. So that basically means if a person is found not guilty in court, then that doesn't mean that the police, therefore, did break the law when they were pursuing them, because, when the police were chasing after them in a police car at 100 miles an hour, it turns out that person was innocent, and therefore the police didn't have the right to chase after them. Therefore, they went in the pursuit of crimes. It wasn't a crime, so therefore the police officer must be guilty of speeding. That's effectively what this gestures at in kind of, sort of, I don't know if you want to use the word homage or premise, general so therefore that means that just because if you haven't got enough evidence or fail to prove a case to either House of Commons, surely that means therefore that you still can claim the right. You still have a right to claim the right to petition and its provisions, surely. The seat is not to be claimed in a petition under Acts unless enough votes had. Therefore, the same seat can be proved. You see, that's just like winning the case. Obtaining the seat is actually winning the case. But this election petition is to challenge the actual petition. So that's just to challenge the petition and its legitimacy. Not actually. See, there already was a case. This whole thing is a petition challenging an actual case, an election case that took place. Now, the problem when the police are bringing criminal charges against the right to petition is that the criminal procedure rules aren't there to challenge petitions to either Houses of Commons. The Tumultuous Petitioning Act was there for that, and they've repealed it, and you only had to use that act was only enforced for a very large number of people. And it's got its own... Maybe you just can't be prosecuted, you know? Although the act was still in effect. I think... I'll show you the basis of... Where's the other... let me search for the word indemnity. See, look, the presence of the public prosecutor. The trial. The trial itself takes place before two judges of the High Court and is conducted in accordance with the ordinary principles as to practice and evidence prevailing in ordinary trials. But it's not an ordinary trial. It's an election petition trial. But it's similar. 4 matters only are somewhat special. 1. Agency. 2. Excuses. 3. The presence of the public prosecutor. And 4. The granting of certificates of indemnity. So, number 4, the granting of certificates of indemnity is paramount and one of the special natures and inclusions of this type of proceedings. But otherwise, it is conducted with ordinary principles as to practice and evidence. So that's like, civil or criminal procedure rules. But it's true that if you know the civil procedure rules, Magistrates Court Acts and all these, if you really know them, you know that there are some clauses in there where if certain criminal matters are raised or arise, they can be dealt with. It can be dealt with, but it's brought as a civil procedure. But you do have a public prosecutor there. So that's why it's special. Because it's not criminal proceedings, right? Well, that's why it's special. Because in civil proceedings, right, you don't have a public prosecutor present because no one's been prosecuted. But this is why it's special. Because you have got a public prosecutor, right? But it's done under ordinary procedures of court, like civil procedures. Now, the ironic thing when I was at Leicester and I got my civil hearing, although this is under the jurisdiction of the circuit in the Midlands of Leicester, which I don't think's in jurisdiction anyway for my case, but she asked me if I wanted to have it heard at a Crown Court. I should have said I wanted to have it heard at the by the Privy Council, or I should have said, it's under the jurisdiction of the House of Commons, milady, that through the Constitutional Reform Act, Section 5, representation of the House of Commons. Can you make arrangements for that, please? Or with the High Court? I could have said that, but then I, as much as could have said, I wish to lay a certificate of indemnity. She could say, what's that? Well, I say, we'll look it up. It's a special type of proceedings and things are slightly different. In fact, I could have raised that matter in my second hearing, but I don't think it should have gone that far, to be honest. There's the wrong type of proceedings, even in that court, with Watson. The presence of the public... So these are what are different about it. Because you can have crimes and offences, but you're protected from them in a way. But, because you're ascertaining... he explains that in a minute. This is a bit complicated to do with privilege and immunity, but they can be non-imprisonable consequences or penalties even for protected people, obviously like removal of position or suspensions, and that's basically effectively the type of thing that the Judicial Conduct Investigation Office is dealing with really in their work, which is like the committee, like the Painted Chamber Committee, really, which is not really that much different from the Petitions Committee. I think that the House of Commons, well, maybe in the House of Commons Privileges Committee only deals with MPs, but if you're petitioning the House of Commons now and we don't have the Tumultuous Act bodies and the case management, special case management, then you haven't got, you don't have all this. But it's here, isn't it? You see, this is the flaw now with Extinction Rebellion, Just Stop Oil and Insulate Britain and Stop ULEZ cases that the police are bringing. They're dealing with it like a normal criminal case, and it's not. It is effectively, it's a trial itself, which is meant to take place before two judges of a high court. It's conducted in accordance with ordinary principles as to practice and evidence prevailing in ordinary trials at issue previous for matters only at somewhat special. One agency, two excuses. Well, that's what Extinction Rebellion, got excuses. The presence of the public prosecutor and the granting of certificates of indemnity. Well, that's what we're missing through the whole thing, isn't it? In a way, really, the statutory instrument, you see, this is the thing, right? If you've got Angela Ditchfield, for example, and she's spray painted the Extinction Rebellion, beg your pardon, on a wall, and if that is under the Town and Country Planning Act, Class F, then you're in the use of enactment, you're using the right to petition, which acknowledges you are petitioning, which acknowledges your class of sign, which acknowledges your deemed and express consent, which annuls the statutory instrument. Therefore, there is no charge. So you're not defending a charge. You're not defending a charge because there is none, because the charges in the instrument, the fines, are subject to an annulment, right? So you're not defending a charge because there is none, because you're using a right. So that is annulment of the statutory instrument's effects, really. And that is like in the Justices of the Peace Act 1997, which is, in pursuit of a resolution by the Houses of Parliament, the statutory instrument is subject to annulment. That's it, right? Because you pursuit of a resolution to either House of Commons by petition. Now, what the police chief really, this is like, have you seen that Churchill dog on the adverts in the back of the car that wobbles its head? Like, ugh. I've seen a police officer do this. Phil Tyson, which is quite funny, isn't it? Like Mike Tyson, the boxer, like the wobbly Churchill dog, like at the back of the car. Oh, its head's falling off, like wibble wobble, don't like it. I'm being questioned here about, putting up petition notices, but actually you got illegal road signage up there. Oh, but yes, so we're discussing on this recorded police interview tape illegal road signage. Oh, don't like it. His head's going, don't like this. It's let go of the bone. Come on, Tyson, let go of the bone. Don't like this. No, you've got illegal road signage up. I'm actually using the right to petition. We're protected Class F. It's illegal police canvassing. of my petition notices and the Representation of the People Act to legal police canvassing. Don't like it, don't like it. Come on, Tyson, let go. Let go of the case, Tyson. Put the case down. Put the case down, Tyson. There's police collar. Let go of the collar. Go on, Tyson. Good Tyson. Don't like it. Ooh. Naughty dog. Criminal Damage Act. It shall not be construed as a defence against a charge, because there is no charge. There is no fine under the statutory instrument Town and Country Planning. There are no fines because of a right privilege or interest, because it is subject to annulment of Class F. There is no fine because the statutory instrument does not apply. So how under the Criminal Damage Act 1971 it shall not be construed against as a defence against a charge if you're using a right, privilege or interest, right? So first you have to claim a right and be using one, and there is no charge to defend, because then we're talking about something we're into the realms of the right, and this is what these 4 special things do. But you don't even need that in the statutory instrument. The statutory instrument is actually, that statutory instrument is written to do this. To do this without merely by recognising, what class your material is and what law is in effect, and then the act is subject to an annulment because you automatically get deemed an express consent. Although it doesn't say, there are a couple of clauses that it claims aren't, but it doesn't say which enactment you're using. There are different acts of law you can use. I think the 1688 Bill of Rights for sure must annul all of them, because they could be another law that you use. There are multiple acts you can use, like Criminal Law Act 1967. The police can use it if they're putting up witness appeals, for example. But I don't think they're petitioning either House of Parliament now, and that's different. But the police don't get charged for putting up witness appeals around public, that's for sure. Under local jurisdiction, agency for the purpose of election petition is established a principle of law, of which are peculiar. We're just going to check on the word agency. Agency is the quality of moving or exerting power. All right, that's interesting. So if you're exercising rights and using a legal process, you are moving or exerting powers. The state of being in action, operation, instrumentally as the agency of providence. The office of an agent or factor business in interest with the concerns of another as the principal pays charge of agency. But the quality of moving or of exerting powers. Let's just look at the modern. This is the 1800s definition. The modern definition, it says a business or an organisation where you can organise people together, providing a particular service on behalf of an other business, person, or a group. Well, you can have a political body, can't you? Like in the VAT, Value Added Tax Act, a political body. So it's a group of people or one person. Either one person or a group what is organised, right? And they can be using or exerting powers. So that would qualify for a group or body bringing a petition to the government exercising powers. Agency. So agency for the purpose of elections petition is established by principles of law, which are peculiar to the subject and which are of such importance as to require a separate chapter as to the law and practice as to proof of corrupt practices before agency is established. It says that it's particular or peculiar to the subject. Well, if it's peculiar to the subject, if you were therefore on those definitions that we've just looked at, if you've got a body or group that is moving with powers which are peculiar to a subject, that would suggest that it matters what the subject matters. If it's peculiar to the subject, then the subject matters to the petition. It's peculiar to each petition. So that is like saying, as the case may be. So you can say the case is peculiar to the charge, right? Because if you are charging someone with stealing a car, the case is peculiar to car theft. If you are charging someone with illegal immigration, then it's got nothing to do with cars or theft, but you're still acting with an agency and powers and a body, the police, but it's got nothing to do with car theft. It's peculiar to, well, actually, no, the Home Office bring immigration charges, not the police. So that's like, if you're, so, you know, as the case may be, you know, the petition facts and circumstances are different from case to case. So therefore, you need to take into account, you know, it says this all through the law, you know, as the case may be, or taking all, it says this all through the whole legislation of the law, taking into account the particulars of the case and all facts and circumstances surrounding it. Well, like with my case, when, you know, the dangerous driving charge, I was in pursuit of, you know, investigating illegal road signage. But I don't know why magistrates just like, they just glaze over. When you come out with this stuff, you read the law and you're like, oh, right, yeah, we're taking into account all facts and circumstances of the case, as the case may be, with regard to everything. But when you go in there, they're not interested, they don't want to listen. They glaze over and they go, like just like that other guy who was on Verbs who went in and proved corrupt practices, and he said he went to the magistrates and it's like, oh, was it a couple of turkeys? You know, they're not, they're either not equipped, they don't have the capacity, not capable or willing. They either don't really know the law or understand what it says, or they just are not willing to, they don't want to entertain. The worst thing is that when you are watching television, you know, and you watch these courts, they make it look like, oh, you know, we really want to find out what happened here. We're interested in this case. What happened? This is why we're calling all these professional witnesses in and so forth. But when you turn up with a big pile of books and that and stuff and sit down, there's been a few occasions where I've been like, yeah, I think this person's kind of interested in, you know, what I've got to say, or, you know, to explore it. But on those particular occasions, there were other factors where I didn't want to, we didn't go. But when there was people there who were the right people to hear it, and for other reasons, it did not flow that way. It was either adjourned or other. And when I was there, whenever I've been there ready prepared to, go through the whole rigmarole and the details, they're just not wanting to entertain them. So it's a very, 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 this is what they'll admitted to the bar is, and being a lawyer, because you make them go through the process and procedures, unless you've got a really rubbish one and you go through like really, put a weak case. But, it's all right if you've got command of the courtroom. If you're putting a weak case, it's all right being admitted to the bar and having command of the court and procedures and so forth, if you're not going to maximise the use of them thoroughly. This is the whole point of finding a good lawyer or who's passionate about a case and not going to rip you off, Although I've had, on occasion, I've had, I've had, on rare occasion, I've had lawyers and, literally one-liners, literally, on the premise of the premise that education is more beneficial than punishment. I'd like to suggest request my defendant is put on the naughty boy speed awareness course, not the driver training course. Yes, very well, but we'll have to ask permission of the police chief constable. But this is a court with judges. Why do you have to ask permission for the chief police? Can you make an order? Oh, no, I have to get his permission. And I mean, who's in charge? Who's in charge of this court? The police chief. Agency for the purpose of... That'd be interesting if there was a jury there, wouldn't it? If you had a jury, and if it was a jury trial and it asked if you could go in the speed awareness course, would you have to get permission from the police chief, or could the jury just say that, you could go in it? Although I don't know if they can just have guilty or not guilty. That's an alternative. I think they're finding you're guilty, but I think the judge has to decide on what the punishment is. Maybe just only police chiefs can authorise people to go on the speed course, which is quite ridiculous, really. Talk about judges being able to compel documents and summon people. You just summon the police chief, but he's on his lunch break. Summon the police chief, ring him up, or he's on his lunch. Compel him documents. Compel documents. Ask permission. No, compel the chief police officer. We compel you with the signature of acceptance of this person on the speed awareness course. You compel the signature on the document. You compel this police chief to sign this document. No, ask him permission. What kind of court is this? Using powers of summons and to compel documents. Compel the speed awareness course approval document from the police chief. Well, I'll have to ask ask his permission. Really? Actually, I've seen police chiefs summoned in court in Bromley. Magistrate, and maybe have to ask permission. Please ask permission to summon the police chief constable into the court. It's like, excuse me, chief, could we possibly have permission to summon you to the court? I know. Well, I'll think about it. I'm not too sure if I want to turn up or not. Well, how about just signing this document for us then? Actually, you can sign a couple of documents for me. A couple of warrants I need signing. Oh, no, we're not going to sign those for you unless you give us permission to sign them. Just a minute, I'm asking you for permission to sign these warrants for me. Who's giving the authority to sign the documents around here? I'll sign yours if you sign mine. Agency for the purpose of elections petitions is established in principle of law, which peculiar to the subject. Well, that's true when you're petitioning our House of Commons, depending on what you're petitioning about, because then the type of things that you need to do. This is I wrote this kind of like document called the Requisitions of Petitioning. I submitted it to Lord Walney. as like, you know, the requisitions of petition, which really that's saying the same thing as the peculiar to the subject. The requisitions of each petition, well, the requisitions of any given petition are peculiar to the subject of what the petitions are about, and which are of such importance as to require a separate chapter as to the law and practice as to proof of corrupt practices before agency is established. Excuses under these acts are as for the greatest. Oh, wow, 2. So we've got agency. Oh, so we've got the agency. So that's basically your the agency is just basically the fact that you're doing an official process and you are a recognised person or body that is using a legal procedure. So then you've got your excuses. Excuses under these acts are matters of the greatest importance, whether there is an election petition or not. Persons who have been found guilty of certain irregularities are bound to obtain an excuse from the court. And both corrupt and illegal practices can, under ordinary circumstances, be excused. The matter is fully dealt with in this book under sections 22, 23 and 24 of the Act of 1883, and is not necessary for further to allude to that law here than to point out that the evidence of both sides should be largely directed to the view which the court ought to take of these sections, every one of whose provisions must be made the subject of the most careful consideration. Sections 22, 23 and 24. I'll have to look at those excuses. So 2, the presence of the public prosecutor. The presence of the public prosecutor introduces a peculiar element into these trials. Right, so they're saying that it's peculiar to have a public prosecutor there at a trial. It would be very hard upon the respondents if the public prosecutor might take up and drive home, this is the part that I've quoted before, any charge which the petitioners did not dare to put forward. So that, if that isn't, you're lying to me. So you're lying to me if you don't think that that has got anything remotely to do with the fact that if you know that you are acting under the 1688 Bill of Rights, right to petition, and all prosecutions and commitments against you are illegal, then you would not have the courage to take up the right and even act, even protest, even turn up at demonstrations, even engage in the investigation work, or even go about collecting the signatures or making and putting notices up through the Town and Country Planning Act. If you didn't know that you had the right to do it, you wouldn't dare because you would be scared of being fined. So when it says that the prosecutor might take up and drive home any charge, so it would be very hard upon the respondents if the public prosecutor might take up and drive home any charge which the petitioners did not dare to put forward. So that is like framing the right to petition, isn't it? Because why would, if it was the right of the subjects to petition the king and all prosecutions and commitments for doing so are illegal, right? Why does that line in the sentence contain the word prosecutions? Because it suggests that there may be some prosecutions, right? There might be some. Prosecutions might exist, or someone might try to prosecute, right? But they're illegal, all of them. So surely, if someone believed that a prosecution was illegal, but there was a chance of someone trying to bring it, because that's why it includes the word prosecutions, so it concerns prosecutions. There might be some, but if there are, they're illegal. Then isn't that what this sentence says? It would be very hard upon the respondents if the public prosecutor might take up and drive home any charge, so there is a charge, which the petitioners did not dare to put forward. But this is for election petitions, not petitions to the House of Commons. But it's that, again, it's that this is, you couldn't be closer to the ball. You couldn't have your pen further away from the point. Only that it's peculiar. This whole, what we're reading and writing now and studying is peculiar to elections petitions, not peculiar to petitions to the House of Commons or either House of Parliament or the King. That's the difference. And that's why it is actually a little bit peculiar reading this, because it's communicating and saying things that we are familiar with and would expect and understand with petitions to either of the House of Commons, only that we find that these instructions and procedure rules are peculiar to elections petitions, not petitions to either House of Commons. So, and thus double the chances of defeat. Well, how can you double, triple, or half any chances of defeat when all prosecutions against you are illegal? All of them. There is zero chance of defeat if you've got the right to petition. Although it only defeats the prosecutor, doesn't it? If it's the right of the subjects if it's the right of the subjects to petition the king, right, and all prosecutions for doing so are illegal, you're automatically defeating the prosecutor because he can't prosecute you. But you're not necessarily proving your case to the House of Commons and winning the case, or defeating the Petitions Committee or the Prime Minister or whatever party are opposing your petition. But you are defeating the prosecutor. Do you see? There's double the chances of defeat. Well, you know, it's doubling the chances of defeat if they're restricting how much evidence you can write on the petition, if they're not even letting you publish it, and if they're making you collect 100,000 signatures as well. That is doubling your chances of defeat, I would say. They're even trying to defeat you. In fact, not only are they ignoring your right to petition, protection and immunity, so that the prosecutor is defeating, the police are defeating you, but Parliament Petitions Committee are defeating you. Even when we collect 400,000 signatures to the First Minister of Wales, the entire country of Wales collects 400,000 signatures, which is meant to 4 times more than required for a referendum of all Wales. He's still defeating everyone because he won't even give the referendum and let them have their own referendum so it can be fairly decided by prescribed law. He's defeating the people, and he's standing down from government. So are you defeating him and he's standing down? But he's meant to be elected and selfless, like the councillors in the chamber, to act on the people. And the people have got enough signatures for a referendum, so they can decide, and he's the facilitator. But yet, how can you defeat a facilitator who's selfless? So he can't be selfless, can he? But yet but the people are defeated when they don't get their referendum, but the referendum is not. The referendum is to be the judgment, and it can go either way, for or against, and that's a argument, a contest between the people, not against the Prime Minister. He's a facilitator, or the First Minister is a facilitator. Yeah, he plays dead like a dog. He falls over and goes, oh, you beat me. I'm not playing this game anymore. I'm going home. But how can we beat you? You're selfless. You're acting on behalf of the people, and you got to provide facilitation for this referendum. But then the people might vote, and then they'll beat my party. So instead of letting them actually really beat me, I'll actually just, I've fallen over. Mark Drakeford. I've got a floppy. I can't do this job anymore. We can't have that referendum anymore. What a shame. I've just beat the entire country of Wales by playing dead, But by the way, and if that, you'd be better off getting prosecuted by the prosecutor, but getting the referendum. Get prosecuted by the prosecutor. Drakeford needs to be prosecuted by this prosecutor for corrupt and illegal practices. He's not acting selflessly, is he? He's acting on behalf of the Labour Party. Now, he's only acting on behalf of the Labour Party when on the electors, when people don't cast their opinion, and he's doing things without people petitioning, or without holding a consultation, or without them asking for a referendum. When he's just going about the rest of the business and people aren't entering an opinion, then he can do what the people who elected him to do can do. But when they're asking, when they on any one point was peculiar to the matter at hand, and they say, right, we'll have a consultation on this, he's re-questioning them, which has got to be a separate matter to the standard general matters of the policies through election, because you're clarifying on one point. Everyone has a chance to respond. If they don't have an opinion on that point, including everyone who voted him in, then they don't respond to the consultation. Surely, the public have submitted 400,000 signatures to say that they want the prescribed referendum. Drakeford is not acting selflessly. Worse than that, what he's doing is to beat Wales, the country, to cheat them out of their referendum. He himself is kind of like being defeated. He's falling down, so he can't actually do a job, or refuses to. I think that's a corrupt practice. There's no reason why he couldn't stay in government. It's politics, it's politics. All this Keir Starmer honour, politics. We need to ask John Bercow, Professor of Politics, when you were at university studying politics, right, are you learning prescribed law and procedures that is presented to the public? Or are you teaching people, you better not say this or do that, it'll upset a lot of people, right? There's two things. There's political engagement where, it's not a good idea to say or do this. It could piss everyone off and there could be riots, or we'll look bad and lose our votes. So there you're acting, you're conducting yourself to please the public or to look good or to try and improve your image or persuade or gain support, or you're only acting as to not disturb or upset people. But he's happy doing that when he's putting planning permission through, even though people don't want things built. He's banging the hammer all day. Bang, 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 bang. Oh, that's just to upset a load of people. He's not bothered then. But when it's, we can't confess that we're corrupt, or we can't, say this, there'll be chaos, there'll be people, they won't vote for his party. Then he says, oh no, I'm not going to say I'll do it. But he's happy doing it when he's slamming the hammer down and making orders. It doesn't make sense. What are they teaching them in these politics courses at university? Do we have legislation? Do we have prescribed procedures? Do we even have a framework for government? Or is that all tosh? Is Bercow just teaching them, oh no, don't say this, don't do that, in order to, get people to buy your buns, you have to lie and say, oh no, they're not really that bad for you, they're quite tasty, aren't they? Get a few more down you, yes, sir. This is it. It's like Prime Minister's questions, isn't it? No, I won't answer your question, I'll just, give some excuses and bluff my way through it. Is that politics? No, why are they stood at a table enacting legislation into effect that they want people to follow? Well, if they don't follow it, well, how do we obtain process and procedure then? There are no process and procedure. Well, there must be process and procedure. Is there a process and procedure? Is there a function of government? What is this? A public consultation? I open the form, I enter my name, I type some words in, I press submit. Oh, it's not a figment of my imagination. It exists. Someone built it and, made it work as a function. There's John Bercow, how to fill in a public consultation form, but no, it's just pretend. It's just a joke because, we can't really have those public consultation forms, we have to keep everyone happy, give them happy buns, or rosettes, In fact, don't tell people to vote for Conservative. We'll just put a picture of Alex Salmond with Ed Miliband. Don't vote for SNP or Labour. We can't say vote for Conservatives. It's politics, Yes, we can mock and belittle our opponents, but we can't glorify ourselves in our own Tory adverts unless, well, actually we are glorifying ourselves because we're making Ed Miliband look like a tiny small person in a top pocket, and Alex Salmond smiling down, on him. That's politics for you. Yes, but you had to rent out a billboard and procedures, and it's Boris Johnson. No. It's Boris Johnson. I can't look like a buffoon in front of the entire country and make corrupt mistakes. And that will be no good for my political party. Well, it doesn't seem to be doing too bad for them at the moment, does it, Boris? Except in Rochdale, we can't have a buffoon in control of the country and writing a column in the newspaper going down, 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 dive into the depths of hell, down, 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 crashing a Lancaster bomber into the moors of Rochdale, down, down, the Lancaster bombers come back from the war. Johnson is coming out of his career as Prime Minister in flames like a Lancaster bomber and crashing on the moors, no, that's not half of the story. And until George Galloway comes up, then Rishi Sunak really is going down in the polls. This is the thing with Johnson. How can Drakeford stand down from Labour? He doesn't want when process and procedure. If these processes and procedures are too controversial to run, like having a referendum over, whether we should carry on with 50 mile an hour and 20 mile speed limits fairly, we can't do that. Well, but why do you have the procedure then? It's what's the point? What's the purpose of it then? What's the point and purpose of it? It's just ridiculous. Why just, let people vote on things and they don't want the vote, do they? You know, get all the complaints out of the cupboard, you know, all the police complaints, you know, about the speed cameras and complaints to the ticket officers. Let's count them out, you know, let's just calculate them. Command them all as evidence in the petition to Parliament. You know, I command every single complaint to every single police station in this country that expresses its dissatisfaction with the speed cameras. I compel these documents to the Lady Chief Justice as evidence of the public. I'm not satisfied with this process, and to weigh them up with all the letters that were in favour of these cameras through every single police force in England since 1990, and I command these documents with directions hereby through command these documents through representations to the House of Commons for a resolution on the entire speed camera network, on the basis that I believe that there are petitions in writing to the police forces of His Majesty's police force forces of all regions of England versus totality to show evidence of complete rejection and disapproval of the entire franchise of speed enforcement cameras, Your Honour. And I give directions for these documents to be compelled to the House of Commons immediately of effect from every single police force, whether by the Attorney General, Director of Public Prosecutions, or the Judicial Conduct Investigations Office, under the premise that, you know, magistrates are really the cause of the whole complaints. You know, this is it. Well, complaints against judges, you know. You could compel, you have the Judicial Conduct Investigations Office. You know, I hereby compel the complete archives of all complaint against justices involving speed cameras to the House of Commons Petitioning Committee as evidence by petition, you know, since 1990, you know. How about that? We could add it to my petition. It could be amalgamated to my petition. Could be amalgamated. Could require it to be amalgamated to my petition because there are complaints regarding speed fines and cameras. In fact, I hereby compel every single complaint to His Majesty's Police Force concerning speed cameras in this country since 1990 to hereby be given as evidence in writing of dissatisfaction with the speed camera franchise and be compelled for amalgamation to my House of Commons petition on the matter. How's about that? That'll be more than 20 signatures. I'll tell you that. I might make 100,000. Might make up my 100,000 signatures that I need. There is what section of this we're on now? Anyway, back to this. So the excuses, we've got to check those out. Those excuses. The granting of certificate of indemnity. The granting of certificate of indemnity is consequence on the obligations of witnesses to answer all questions relating to any offence at or connected with the election. Well, you're the one. You're bringing a grievance or case yourself in the first place, and you're wanting to call. You're calling your own witnesses. You've got your own case with your own witnesses when you're petitioning either Houses of Parliament. That's the thing. Without being able to excuse himself on the ground that the answer thereto may incriminate or tend to incriminate himself, or on the ground of privilege. So the granting of certificates of indemnity is consequential on the obligation of witnesses to answer all questions relating to any offence at or connected with the election, without being able to excuse himself on the grounds that the answer thereto may incriminate or tend to incriminate himself, or on the ground of privilege. So you can't actually use privilege as an excuse to not answer the questions, or even you can't even be excused from being put on trial, which I'd like to raise this matter with Jeremy Johnson KC with Lord Hanningfield's basis then. That would be interesting. I think Johnson did say that he twisted it. He did say that there's nothing to prevent Annenfield being on trial, but then he said that cognizance lies with Parliament, and that they decide what his work is and is not. I don't think they actually officially said the jury can hear it, like in Magna Carta, barons and lords come in and judged by their equals, but the newspaper said that. Although I don't have the actual dialogue of proceedings, but we know that apparently that representation only got emailed in at the last minute. He goes on about the clerk. Pottering around doing work outside the court as well, which I might need to reread it. But he tends to suggest that the clerk can do work outside of Parliament. So therefore, Hanningfield can, but maybe I got that a bit wrong. But so he did say that he used this poet laureate etiquette by going, "Oh, there's no reason why you cannot hear this case." No, but Parliament have got the exclusive cognizance. This is it. Maybe he didn't know about this. Maybe he knew about this, or maybe he didn't. But how could Alistair McCreeve judge that it couldn't be heard? We don't. They're not straight up about exactly what's going on with it, because they use kind of like a misleading language, unfortunately, even when you know what happened. But the witnesses must answer truly in order to be entitled to such certificates. There's no such provision or regulation in the right to petition, though, that you have to be honest or truthful, because you're trying information. It might not be correct or honest. I don't know about that. That's the big question. This would suggest that you've got to tell the truth. If someone challenges your petition, House of Commons petition, for any of your crimes or misdemeanours like Extinction Rebellion. But then again, that would mean that you had to go on the matter that you're petitioning, and now the courts have said that Extinction Rebellion can't talk about their motivations or about their casework. The thing is, if they still have the Tumultuous Petitioning Act, they would be discussing all of the subjects, and I was kind of wrong about that. Well, I'm right about it, because the court aren't actually hearing the matter of which they're bringing to Parliament, but in the Tumultuous Petitioning Act, they do. But they also hear the matters to do with the immunities and so forth, like in here, these special... It's peculiar to petitioning Parliament. So the current scope of the proceedings that are being used at the moment is not... It doesn't have the capacity to provide for special reasons. You see, they've got special reasons all through the legislation. Like even that dangerous driving charge had special reasons, which I guess this would qualify for that. But then they remove them and put them into the red traffic, the red light signal offence. But it's meant to, the dangerous driving charge is meant to have special reasons in. You can have special reasons, which then makes that the right to petition pretty much covers, Criminal Law Act, Criminal Damage Act, town and country planning, even driving. Pretty much whatever's peculiar to the case. But you might tell the truth and be honest. It's suggesting that you forfeit your immunity if you don't tell the truth. But I don't know how that goes on with privilege. The thing is, if you've got privilege, you don't need the certificate of indemnity. That's the thing. But does someone with privilege need a certificate of indemnity as well when they're giving evidence? It's only saying if you've got privilege, it may protect you from having to answer all the questions, being in contempt of court. But there's something... The difference with the privilege is that it's permanent, whereas with the certificate of indemnity, you've only received it on the merit that you are required to give evidence, or that you're bringing evidence, which is like the right to petition. Because if you're not petitioning, you don't have protection from prosecutions in connection with that petitioning, But with privilege, you've got it whether or not you have it. Well, have you got it in connection with work for Parliament? I need to check that. There's no Magna Carta reference in Jeremy Johnson Casey's writ, but he refers to another paperwork, another case, an earlier one that set out the principles of it, and I need to read that. I've got to read that because it's important to know whether he's only basing it on that Article 9 of the Bill of Rights, which is only really illegal prosecutions by the King's Bench for matters that are only decidable, cognisable in Parliament. Oh no, sorry. Right. So the petition is, sorry, the election is cognised. The petition's cognisable by the people. Sorry. So the election is we have the power to decide the outcome of the election, don't we? We the people have got the power. The people have got the privilege. The people have got the privilege to decide, to judge who is going to be elected into Parliament. But the judge is got the jurisdiction to judge whether it was run lawfully or not. And if it was run unlawfully, he can, say that someone hasn't been elected because we didn't make either we didn't make a lawful judgment or the process wasn't lawful. But it's not the MPs. The MPs don't vote other MPs in. We vote them in. So Parliament hasn't got Parliament hasn't actually got the cognizance in the election, has it? We have. That's interesting. We've got the privilege of judging the MPs, whether they can have privilege or not. All right, yeah, because we give them the privilege by electing them. Right. So the cognizance is not actually. Wow. So the election petition cognizance is not with Parliament. We judge. Well, they can't. If we elect someone and vote for someone, and it's been run lawfully, no cheating. Parliament can't say that. Parliament can't say that person hasn't been elected. I don't think they can return them. We decide who's elected, don't we? That is like, whoa. That cognizance isn't with Parliament originally for the election petition. It's with us. So right with the subjects. The only thing I don't get is the candidate petitioning the people or petitioning Parliament? Oh no, the candidates aren't petitioning Parliament because Parliament don't judge who. Well, unless they make the order, but we're the jury, aren't we? So we've got cognizance. The public have got cognizance in the election, don't they? We've got cognizance with the election petition, unless it is not run properly, which then it goes to the judges. But the judgment is on our judgment. They're judging whether our judgment's been done lawful or not. So the candidates must be petitioning us then. We're not petitioning Parliament. Well, it's run through common. Well, it's the common people, the commons, isn't it? It's the common people. But that's where the headquarters is of it all, in Parliament, isn't it? Unless it's a local council authority petition. I don't know how they're doing all these punishments and crimes then to do with this, but a lot of them are just fines and so forth, or you lose your vote, or you lose your right to vote and so forth. but the witness must answer truly in order to be entitled to such certificates. Well, the thing is, if you actually are petitioning a case, if you're bringing a case, and that's really what you are doing, and you really are investigating something, you've got entitlement. Something you're entitled to, if that's what you're legitimately doing in pursuit of it. That's the thing. You got a right to do that, if that's what you really are doing. So you get your indemnity. You do get indemnity. The right to petition gives you indemnity if you really are doing it. And the prosecutor. So yeah, so if you're really doing it, you can't be defeated by a prosecutor. If you tell that if you are really doing what you say you're doing. But even the thing is that it's less. I think this is less about punishing. It's got less to do with punishing the actual participants than establishing whether or not it was run legitimately or not, and who has been elected and who has not been elected. It's more about establishing that than the punishments, although when it comes to privileges, I don't think the judges get imprisoned or prosecuted. They can be found guilty through this, but I just think they get taken off the judge rota. It's like an MP and the Privileges Committee getting removed or standing down, like Johnson, basically. Like that. Surely you can have impeachments. Impeachment by the House of Commons is not subject to pardon. Cannot be pardoned. You don't do them. I don't know why. I guess only for corrupting legal practices and not telling the truth. Not for... This is the thing, but why would you be in front of the Privileges Committee? Obviously, if you've got privileges or not. At the conclusion of the trial, so for the granting of certificates, this must be borne in mind as an element in determining the policy of making this or that charge in an election petition. Well, the thing is, when you draft a petition to the House of Commons, you might be you're allowed to accuse people of things or bring a grievance against a person. So you are bringing a charge, or setting out some other case, or making a policy of government. It's using this word policy on purpose, like, you know, why deny that? It's peculiar, but they're using the word policy now peculiar to election petitions, not using the word policy peculiar to petitions to the House of Commons. Determining the policy of making this or that charge. Well, that's what it means. Look, this is exactly the type of material that we need to be looking at when we're working all this out, which we're not getting in the Tumultuous Petitioning Act. I wonder if there is an act in the charter. I wonder if they've it's not on legislation.gov or any other website. I wonder if there is one that like this. I wonder if there's an act that is like this, but peculiar to the Tumultuous Petitioning Act, in greater detail, or not. Or I wonder if they can't have one. But then again, in 1688, why didn't they get rid of the Tumultuous Petitioning Act in 1688? Or does the part of the Tumultuous Petitioning Act where people get prosecuted at the end, does that bit get, is that bit at that point subject to an annulment, and only the rest of it through the... I can't understand how the Act continued after 1688. Maybe it didn't. Maybe they're lying about it being in effect till 1986. We need some procedure. There's got to be some of those. I wonder if that. I wonder if those were the. I wonder if all those House of Commons ones that got burned in the fire of Parliament got burned. I wonder if most of them got burned. We've lost all the evidence in 1800s. I wonder if we lost all the evidence in the 1800s. You see, this is... All right, this is 1883, isn't it? All right. Whoa. Just a minute now. This is... Hold on a second now. My brain's actually still managing. It does work. Fire of Parliament 1834. Wow. So 1834, 30, 40, 50, 60, 70, 80. So that's 50 years. This is 50 years after we lost the majority of the House of Commons petitions to Parliament from the Petitions Committee archives, because Parliament burned, and Dr. Brodie Waddell has confirmed that. He agrees with me, does Dr. Brodie Waddell. He agrees that that they got burned, because he says they got burned. So we've got the quarter sessions petitions, we've got the Privy Council ones, or whatever is left of them, and the House of Lords ones. But he hasn't translated all of the whole lot. He's translated like thousands, about, I forgot how many, 11,000 or whatever. So there's thousands. They've translated thousands of them for us, so we can get a good idea what they were about. But there's the odd. There's some of the House of Commons ones mixed in with them. There's a few that ended up, getting in with the others, or passed from department to committee to committee, or however they get. There's the odd one that is House of Commons originally that might have got passed to the Privy Council or from quarter sessions or whatever. But he said that there were. So this committee of motions of griefs and petitions, which was started in the 1500s. So we lost a very, very, very body of history of England, which is quite significant, and that is a lot of evidence of the process and procedures. And if we don't have any other act of law besides the Tumultuous Act in the 1688 Bill of Rights, and then what we can make out of that. But 50 years after all those petitions are lost and burned, we presumably still have a committee in Parliament that's dealing with them, surely. But they're enacting legislation which is the exact nature, manner and type of specific, special, unique procedures that we really need to know of if they exist, or if they did. But instead we've got them enacting very extremely similar, which is peculiar to election petitions, and requires four special procedure rules. Well, these are procedure rules. There's four special procedure rules that are absolutely required for it to function properly, that are not being included in current law, in criminal charges or in civil cases, and they're critical to unique type of legal action that it is, because it contains a right and privilege that is not being facilitated for or acknowledged properly by the Crown Prosecution Service. Yet they themselves have and use an extremely similar one when they are bringing cases themselves to a local criminal court under a local jurisdiction. They're accessing certificates of indemnity from the Attorney General, but they are refusing to entertain that the idea even exists, but yeah, they use it. The conclusion of a chapter. So, it would be well for the party and every person could be made to understand the statute. Look at this. This is joke. It would be well for his party. It would be well for Martin DMP's party, or maybe Scott Benton's, or any other of the 11 members of the Petition Committee or chair. It would be well for their party, wouldn't it? It would be well for the Petitions Committee 11 members if every person who concerns themselves at all in the work of an election could be made to understand the statutes which form the subject of this book. Well, I never. Can you believe that? It would be well for the Petitions Committee if every person who concerns himself in all the work of an petition to House of Commons could be made to understand the statutes from which the subject of the running of the Petitions Committee was run on, not just standing orders 145A or 158 or whichever from the standing orders 2023 or. It would be well for his party if every person so this you could not be. You see, look, we've got problems with political parties. That is really the main problem at the moment, and in the local councils as well, in these planning orders, planning decisions. In this book is even, he says all everything that he's writing in this book. He's giving citation here and credit that it's all based on the principle of statute law. Can you believe that? He's accrediting that the subject of his book is reliant on the understanding of statute law. Right here, look. Right here. Of statutes. Last chapter to be launched, and in particular to study the last that we set out and discussed in the last chapter were to be launched, and in particular to study the peculiar law of an agency obtaining in these matters. Well, we've said that the word agency means that a group or body or person who is acting through powers or authorities, which you're doing. Peculiar law of agency obtaining in these matters. Well, it's definitely peculiar. Although it's not meant, you wouldn't have thought so if it was like the one of the main acts of law put through England at the time. I wonder if he mentions any hints about those things getting burned down. And the next best thing is that all such persons should place themselves wherever in doubt in the hands of the election agent. It will be seen in later chapter that high authorities have often compared the position of agents for this purpose to the persons who are de facto on board a yacht at the time when she is sailing in the race. We may perhaps extend We may perhaps extend the analogy and say that while the candidate is like the owner of such a yacht, the election agent is like the captain to whom he has entrusted her. The election agent is therefore above all the person responsible for the observance of the Acts of Parliament now before us, but he must be loyally supported by all concerned, including the candidate himself. Now it must be remembered that in practice an election agent is not employed solely or principally to carry out the provisions of the Corrupt Legal Practices Acts. It must be remembered that it is not employed solely or even principally to carry out provisions of the corrupt. Well, who is? He's employed to win. To win, of course, by fair means only, but to win. Lawyers without experience or actual election work are apt to forget how heavy it is the work of an election agent entirely. So they've got their election. I'm complaining at the moment to the Electoral Commission. They say that they're not. None of these bodies want to claim responsibility. It says that, I think the law's down to the police at the end of the day, and down to anyone who calls out, anyone who identifies and calls corruption. How do you get it into the It involves the Crown Prosecution Service. And it ain't the Home Office bringing it. It should be reported to Parliament. Who's work with the colossal magnitude. I don't want to read this whole book. I want to. Where's that other? So the agency, the excuses. We've got agency excuses, and the certificate. Agency excuses, or the prosecutor, and the certificate. The excuses. So we want to get to 20 sections 22, 23, and 24. Be warned on the subject. Canvassing book should contain a warning on the cover, and written appointments such as the subject should contain upon a face. 22. The excuse. If in spite of all care the maximum amount is exceeded, or if any other illegal practice has been committed. It's been made for an excuse in the 46 and 47, where if the precautions above named are proved to have been taken, there ought to be a fair chance of success under subsection B. This application, unlike that under section 22, may be made to the High Court and is not confined to a case where there is an election petition. In spite of all care, the maximum amount is any other illegal practice has been committed. Application must be made for an excuse. An application must be made for an excuse in 46 and 47. Where if the precautions above named are proved to have been taken, there ought to be a fair chance of success. This appointment is made to the High Court and is not confined to a case where there is an election petition. Well, if this whole thing's about election petitions, then it could be other corrupt and illegal practices. So it might apply to a petition to the House of Commons. The same true in application of Section 24 of the same Act for an authorised excuse. An authorised excuse for non-compliance with the provisions of Section 3 as to the return the declaration respecting election expenses. Either of the applicants should be made to the provisional court. The excuse contemplated by Section 2 relates to corrupt practices only. Corrupt is usually, if you don't tell the truth, it is a matter of the election court only, and the trial of an election petition only. Well, the thing is, when you're bringing a case, it's like police, you know. What are the matters of the police chasing a criminal or kicking a door down to get a criminal is a matter of his case to the court. Now, someone can do actions against the police, but they rarely do. But lots of people do actions against the police if they believe the police did something wrong or corrupt practices. So it's almost like actions against the police. The police aren't... This is the thing. The police aren't treating their prosecutions against petitioners as in the same or a similar peculiar way as a solicitor or lawyer treats actions against the police, because actions against the police are usually a separate action to the case where the police did the actions, right? But you can't be prosecuted there. It's illegal to be prosecuted, but you have a prosecutor present, but the prosecutions are illegal. So you've got excuses. So this is looking like you sort of like you might be breaking the law, but you got an excuse, and if you're finding out that you are actually doing something under protection and you can't be prosecuted, and that's what the prosecutor's there to establish, but they're not going anywhere near that. They're not even acknowledging, they're not entertaining, they're kind of blanking the fact that you are even engaging in such a thing when there's meant to be a particular special proceedings which has special provision in it for that, to take that into account and look at it and consider it, which is one thing they don't even want to do. And for example, if the excuse, look, that statutory instrument, Town and Country Planning Act, is paramount in this. It's literally like the gold standard, because it not only gives deemed and express consent if you are using a certain act of law, enactment in a certain class. It makes this statutory instrument, it doesn't apply. So you don't need an excuse for breaking the law and then protection from doing it, because the instrument says that you're not breaking the law. It allows you to do it, because those are some of the things that are the majority of activities that the statutory instrument 2007 concerns are peculiar to petitioning. The extent and nature of the activities covered in the 2007 statutory instruments are peculiar to petitioning, particularly a very peculiar class in Class F, which basically makes the instrument annulled, practically. So therefore you don't need an excuse, because you haven't broke the law. So it's not like, oh, I've got an excuse for breaking the law. It says that the law, you're not breaking the law. You aren't breaking the law. And this is the thing with the Criminal Damage Act, which police really doesn't like. So this is the thing that the police don't like about the Criminal Damage Act 1971. They really, really are wrestling with this defiantly, because they don't want to entertain, like in these proceedings, we've got these 1, 2, 3, 4 very special, unique proceedings, particularly to this, and they're not there. But yet, the Criminal Law Act provides for that. The Criminal Law Act says that, it will not be considered as a defence against a charge if you're using a right privilege or interest, which means that if you are using a right, which says you can't be prosecuted, it's suggesting that you're not defending a charge. But why? Well, either you did break the law and it is a crime, but you can't be prosecution is illegal. But the police and the Crown Prosecution Service like to see that Criminal Law Damage Act 1971 as vaguely as they can. They like to read it extremely vaguely so they can be in contempt of it. Because if they, it is, let's say this, it's the Criminal Damage Act 1971 couldn't be more compatible and absolutely not in contradiction in any way with the 2007 with the statutory instruments for the Town and Country Planning Act. Couldn't be more compatible with that, in the sense that you get deemed an express consent and there is no offence if you are using a right privilege or interest, which is in the enactment. So it's not only it literally fits together with it like Lego bricks, but it's a Lego brick which the police really do not want you to attach to, because then he cannot use the Criminal Damage Act, and then he starts shaking his head, and he doesn't like it, like don't like it. But, you know, people don't like it when police are kicking people's doors in, when they are, you know, breaking in and entering into their houses and so forth. People don't like it. They're like, don't like it. You know, and I would suggest that, you know, this is a very, very, very interesting thing when we get the emergence of the police. You know, when we get the police force, Bow Street Runners and the Met Police being created, and less smaller random groups aiding sheriff or constable, and the police being specifically designated to bring criminal cases and try them and be organised. And what are the chances throughout the entire history of England, when you've got this surmounting force, body, very extremely large body of persons, therefore then designated to be the ones who will bring prosecutions, yet you've got the public at large who enjoy the privilege of bringing such challenges of prosecution along with other matters, with protecting themselves. Surely they're and they're exercising a lot of rights and exemptions. You've got a conflict, because what happens if those members of the public are bringing actions against that police force? That means that they will be almost opposing them. And isn't it an absolute miracle of timing that would be when the Houses of Parliament burned down and we lost the entire main archives of the House of Commons petitions? Out of the exact, you know, what petitions would we be more interested in looking at of all of them? You know, from John Pym and the Civil War, which would help clarify the process and who's doing what and what could better fill in the entire detail of stories around what's happening, and landmark cases, you know. It's almost like the disappearance of the liberal free houses and pubs and taverns in Huddersfield, you know, following on from, you know, Imperial Chemical Industries and the Victoria Tower, and the demise of Huddersfield and its falling into the hands of the Labour Party and being transformed into a Labour community from a Liberal community. And the town centre, literally all these buildings where these events happen, these meetings, these places happened, and they've all been demolished. All these like Shakespeare's house, old pubs and buildings, just gone. And then people, not really noticing that, and there's ancient sites and so forth. It's almost like all those petitions getting burned in Parliament. So and now we've got all these strange diseases and vaccines. What happened to Bedford? What happened to Bedford? In the Civil War. What happened to John Pym? Excuse a contempt. So yeah, I mean, you're not. It's not. They don't call it an excuse. Coming back to the sheet again, they don't call it an excuse. It's not called an excuse. You just got deemed an express consent. Because they said, oh, you can do these things. The council can do them. When the council do it, I think this is why it's always got special reasons through the law. When it says special reasons, and that's all covers everything that you could possibly think of or do, like even through the earlier highways and driving acts. But they started tinkering with them. Started tinkering with it all. When you can't tinker with it, they're not tinkering with this astute law of what it was founded on. The exclusion contemplated in Section 2 relates to corrupt practices only, and is a matter for the election court only, and the law as to such excuses and the conditions necessary for their success appear. See, if you've got let's look at the driving charges, right? It wasn't actually called an excuse, was it? Even for dangerous driving, it said special reasons. Special reasons not to convict. Well, if you've got a special reason, these are special. These are called special clauses. If you got a certificate of indemnity, then that's a special reason. But it's not an excuse, though, is it? You're not saying, oh, you're not making it. It's like an excuse. It's actually. You could say an excuse is a reason. Special excuses, special reasons, not to convict. So, I mean, let me just let the dictionary, right? What does the dictionary say for reason? A basis or clause as for some belief, action, fact, event. A statement presented in justification or explanation of a belief or action. A statement presented in justification or explanation of a belief or action. I dare you to give me one good reason for quitting school. Verb, used to think or argue in a logical manner. To form conclusions, judgments, or inferences from facts or premises. To think through logically as a problem, to conclude or infer. So this is reason, special reasons. But we know this anyway. But, if you go into a court, in a magistrate's court, and go, special reasons, they won't sit there, whatever you call them, whatever that guy in Verbs called them, the three turkeys won't go, yes, on the premise that a statement I present in justification or explanation for my beliefs or actions, and to think or argue in a logical manner to form our conclusions, judgments, in this court, an inference from the facts and premises, hereby to think through logically as a problem and conclude I am pursuing this investigation for evidence in my case. That's my excuse. But using the word excuse kind of makes it sound like, when you use the word reasons, what are your special reasons, then it doesn't sound like you're bad or naughty or you've done anything wrong. It's like, you've got a special reason why, this has a purpose. When you use the word reason, then you have a purpose. Yes, I serve a purpose, the police officer has reasons for his actions. No, the police officer has excuses. What is the excuse for this? You just kicked my door down. What was the reason for this? Because you stole my sandwich. What is the excuse for kicking my door down, officer? It's the word excuse is insulting. It's an insulting word. It deprives. It deprives the agency. The agency, the powers, the body or group's agency. The word excuse surely steals from the agency of what you're doing. The reason. It's also the word excuse itself is a demeaning term. It suggests guilt or wrongdoing, whereas the word reason is synonymous with or interchangeable with the word excuse, but not in the sense that you were doing anything wrong. Now, if you say that, well, if there are laws that, make things illegal or unlawful, if all prosecutions are illegal against you, then why is that? Because you're not seen to be in the wrong. If your agency is in pursuit of good reason, lawful reason, rightful reason, so therefore there's no reason for excuse. There is only reason to explain your agency, But this is just, being, Jeremy Johnson KC with his, Scarlet Pimpernel and Poet Laureate, whatever he wants to call it. The same is true of an application under Section 34 of the same Act for an authorised excuse. Well, you see, who gives you authorisation in the Town and Country Planning Act? No person gives you it. No authority of commission, no rank, no appointment. You're giving it through the legislation. The law gives you the deemed express consent and on merit of your reasons and your agency. So you're authorised by the agency of the right, not some judge. And if you're telling the truth, and if it's found that you are acting with the agency, this is actually what my complaint actually boiled down to, that currently is still now ongoing with the Judicial Conduct Investigation Office, because what the judge said is he said that he believed that I was investigating illegal road signage. He admitted that I was, he had no doubts that I was petitioning the government and the Petitions Committee. He had no doubts that I was investigating illegal road signage. So Nicholas Watson, he actually confirmed my reason was confirmed. My excuse was confirmed. My agency was confirmed according to law. But he did not grant my indemnity because he did not believe that such indemnity exists or existed when it clearly does. Now, the thing is, the same or similar indemnity exists in the Crown Prosecution Service, which he cannot have been unaware of. He must have known and been aware of the existence of assisting offenders protections. And it's not that different from it. It's not that unpeculiar from assisting offenders. It's the same basis, but rather than an assisting, you are bringing. You're not helping out someone else. You're actually bringing it and doing it yourself. So other people are possibly even helping you. I don't think it actually is different. Right. Ultimately, although it's under a different jurisdiction, it's under the jurisdiction of, well, if the police are bringing cases under a county to courts and judge circuits within that county, and they don't have jurisdiction outside that county, but you're bringing a case to the Parliament of England, it's not even under the jurisdiction of that judge anyway. It's not under his jurisdiction. Although, now, does he have, if we've got, in an election, in the actual election itself, it is the people who are judge, because they are the ones who cast their votes to decide who wins the election, not Parliament. Parliament make the election is meant to be run properly, but who decides who has won? Well, there is a judge. It's like in a court, the jury who have cognizance over it, but the judge just makes the order. But we've got the cognizance, the cognition. Who's got the cognizance in a petition to Parliament? Parliament, but the Petitions Committee are not assisting. They're not giving support. They're not giving any enforcement. Where are all the proceedings, like from the tumultuous, which could be case management? The thing is, the courts don't have... I don't think the courts had... The thing is, I don't think in that tumultuous petitioning act that those three justices or the large part of a grand jury, I don't think they had cognizance over the deciding the petition. They only had cognizance over if they didn't have cognizance if it was under 20 people signing it, and they only had cognizance to check it. Not decide on the actual matter that you're bringing to the House of Commons. Only if it checked it was all in order, and we need to know more about that. That I don't think Brodie Waddle. Well, there's those quarter sessions, isn't there? But that's only they want to use the quarter sessions for the prosecutions before we had the protection. Though the three justices or the larger part of the grand jury was not if you've been prosecuted through the quarter sessions, assizes, or King's Bench. That was some sort of where are all the records from? Well, those petitions that went through the courts probably ended up in the House of Commons. The ones that made it to the House of Commons, right, ended up there. The ones that were under 20 signatures didn't have to go through the court. The ones that were, so the petitions that were under 20 signatures ended up straight in the House of Commons, and the ones that were over 20 signatures went through those courts, and if they got through them, then they ended up in the House of Commons as well. And then all of the petitions in the House of Commons burned. Right, so where the fuck are they? We haven't got them. where's the procedure rules for those courts then? For the larger part of a grand jury or three justices or London magistrates or whatever it is, because they are not the quarter sessions. Or were they in the court? Was it dealt with in the quarter sessions? And the ones in the quarter session ones surely were for local matters, because otherwise they would have ended up going to Parliament, because the quarter sessions don't make up decisions for Parliament. You know, I think we've had. I think that Great Fire of London is now possibly even as significant. It's almost like the anti-Bill of Rights, isn't it? It's like we have this amazing event, Glorious Revolution, this Bill of Rights, and we have then this event where all of these amazing cases that must have been brought all through the Civil War and all these, God knows what other matters, there were various contests, challenges, you know, Oliver Cromwell, you know, what about all the members of the public who were contributing to all the history of England? So if those petitions from the House of Commons petitive grievances have been all burned, we've actually lost the legacy of the Bill of Rights, at least between, you know, the 1688 and, you know, the mid-1800s. We've actually lost all of what it was made to do and how we can actually hold the government to account. All the public, basically, the independent opposition against bringing the holding the government to account, the grievances against the government. You know, what are you doing? The power of we the people, the power of the people, that right was made to create, which is literally scandalous. And then you've got, how could Martin Day, MP for the Scottish National Party, how can he, how has he got any self-respect for such being a member of such committee where the entire legacy of the right by which the committee even exists, not even with standing orders, is being destroyed? And they are perverting the course of justice and dominating us. They're dominating us and disrespecting us and even refusing appeals, acknowledgement of any function or right. And they are having the dandy old time calling their own witnesses in on things they fancy, like tampon tax, you know, Theresa May and Paula Sheriff, Priti Patel, you know, calling in witnesses when it's, you know, entertaining tampons, and summoning documents, you know, some new tampon box designs. They can all, oh look, there's Merlin Sheldrake there. Hello, Merlin. You know, you got some more mushrooms growing outside in the fields. You know, this is it. So effectively, you know, when we're holding these MPs to grievance and account and corrupt practices. Oh, what's this here? Oh, it's a Corrupt Practices Act against MPs. Can you do? Oh no, we can't petition about wrongdoing. No way. We can't petition about wrongdoing. Well, what's election petition then? That's wrongdoing of petitions. Well, about the wrongdoing of the petitions committee, try that one. No, we can't have that one. Well, you know, it's Scott Benton. You know, what's happening? These 11 ministers aren't there for their own leisure. It says in the councillors' conduct that the councillors have to act selflessly. I don't think Paula Sheriff was acting selflessly, or Theresa May, when they're entertaining tampon tax petitions, I think that they're wanting to call in Baroness M with a new lingerie collection, and let's have a look at some new tampon designs she's got, and some boxes, and get Merlin Sheldrake in, probably to, can you design us some tampon boxes? That's a nice design. I like the logo's nice on that one. What's this? Bangkok.biz tampon. Oh no, don't like that one. No, I reject this petition. Go away. Summoning people. No, at my leisure. But no, actually, this is my case. How did this case get here? A lot. Someone brought it. They're dumping that in here. It's when they wanted to, I don't know, legalise cannabis. Get a stinky spliff out of here. This is it. What is, where's the enforcement? It's almost kind of like it's a miracle that there are any criminal procedure rules or civil ones. How often do the public use the criminal procedure rules except in defence? They rarely use them through prosecutions now that, it's all handled by the police. And I think that's the thing. I think this is all about the creation of the police force. I think it's all about a standing army. Effectively, the Bill of Rights says you can't have a standing army, but what you got when you got a load of blokes twiddling the things with hands with nothing better to do? They're not defending the country from invasion, so what are they there for? The public aren't presumed to be all criminals unless they're suspected of crime, so why would you need such a force? Why can't everyone, police themselves? And, if you're competent enough to, bring your own criminal proceedings yourself, investigate your own offence. I don't like this. What I think is that the Crown despised Cromwell, despised the right to petition, and this burning down of the House of Commons and all of the petition archives, and this creating of the force was another insult, because you think you got the right to petition, do you? What petitions? They're all burned, and by the way, you shall not have a standing army. Oh, we'll see about that. Not only shall we have a standing army. Oh, that's not the army. The army is to protect us from invasion. We aren't being invaded, are we? No. But what's a standing army for then? We're not, as law-abiding citizens with rights. The police is the standing army that is illegal. The police force is the illegal standing army that we weren't supposed to be allowed to have, but they thought, we'll have one anyway. They thought they'd conjure one up just to everything in that act is being undermined, just to make a point. Even the free speech now, we don't need the police to bring crime charges. And what about all these corrupt practices? This is the thing. What about when the CPS are corrupt practices? What about when the police are corrupt practices? All we get is the odd, case by case, get myself, 10 grand together and actions against the police. And, well, what about if you can't afford it? Well, we'll have to see if we've got the capacity. Oh, no, sorry, we don't have the capacity. This is it. Corrupt practices only. So, this is where I am with it now, anyway. We've got to search for this section 22. The excludes contemplated by Section 2 relates to corrupt practices. So, corrupt. The word corrupt is different to illegal. Corruption is different just to crime. Offences against the law, and corruption is perverting the actual law, not just breaking it, but actually perverting the running of the law. A criminal just breaks the law, but corrupt practice is actually they're engaged in actually the running of the law itself, and that's different. enabling court to innocent candidate in certain cases from consequences of disobedience to what the Act prescribes. Oh, this is fantastic. What else do you want? The most brilliant idea of the Act is that of Section 22, enabling the court to exonerate an innocent candidate in certain cases from the consequences of disobedience to what the Act prescribes. Well, aren't these all genius one-liners that basically say, is the right of the subject to petition the king and all prosecutions are illegal, so it basically alleviates you from being a criminal or prosecutable if you're petitioning. Isn't that the exact? Isn't that just literally different words to say that the court to exonerate an innocent candidate in certain cases from the consequences of disobedience? Well, if they're disobedient to what the Act prescribes, so if you're disobedient, you're not obeying the law, are you? But you're being exonerated. So yet another way of saying the same thing here. When the candidate himself in his election agent have done nothing against the law themselves, when they have taken all responsible means to prevent offences. Well, this is it. All reasonable means to prevent offences. Well, this is it. Well, if you are bringing a case to government that other people have broken the law, well, that's what your grievance is. Your grievance is that other people have done wrong or wrongdoing. But Parliament is saying that you can't have wrongdoing in petitions, which is absolute tosh. When the offences are trivial, unimportant and limited when the election. So whenever you're bringing something to the Parliament of England, it's not trivial. I can tell you that. It's not trivial. It's of national importance. To originate is a suggestion much by the late Lord Bramwell. Commissioner subject is now... Anyway. Why does this keep disappearing? Ah. 21. The agents of the city were seen before the during election. I wonder if this is 22, that the election agent was... Charge. Promise to make up any loss to business caused by voting. Promising to get daughter into Ashford High. Promising to get daughter into Ashford High School if husband would vote for respondent. All right, so this are like, hey, this is like what I'm complaining about Sue Hall for. We'll turn ULEZ cameras off if they vote for her, even though they've already given her a petition of 200,000 signatures, and they're entitled to a resolution from Parliament on the party that actually say that they want the cameras turned off. And they've got enough signatures to have a debate in Parliament over it and do it. But if you vote for Sue Hall, she will do it, even though you don't need to vote for her because you're entitled to a resolution from Parliament. That is a corrupt practice of the Tory party. Giving 5 cents to secure a vote. I wonder if there are these for petitioning Parliament, or if it doesn't count. The thing is, I got someone put some dodgy signatures on my petition, but I didn't actually know. When you ask someone for their details and they give the wrong details, then you can't. It's not your fault, is it? This is the argument with 38 degrees that I've got. 38 degrees. 38 degrees are corrupt practices. They're taking people's actual casework down. They're actually stealing people's casework, and they're acting as judge and jury when there's meant to be a specific process for judging election petitions. In fact, I think I'm going to have to complain about that as well. I've got to get that sorted out as well. So it's actually got some. I don't know if these are just examples or what. Are these official? Oh, it's got some people. John Price of. It's got the names and addresses. Giving. So I wonder if there's any of these for petitions to House of Commons then. Well, if they all got burned before this was enacted, then they won't have all the records, would they? All the petitions got burned. Unless there was a charter like this. Unless there was but even that might have got burned. Rather than the separate sheets of petitions, there might have been a book with them all listed like this. This is what we want. If anyone was petitioning the House of Commons and they'd broken the law in doing so, and what was their excuse or indemnity? Giving railway tickets to secure a vote. But the thing is, in modern law now, look at the Monster Raving Loony Party. They're actually, you join the party, you pay a subscription, and you get a rosette or whatever, or they can give them out anyway, giving rosettes out for people. Although I don't know if you're donating to the party, aren't you? Anyway, you're donating to a cause, but they're not supposed to give to you. It's like Rees-Mogg, isn't it? He's providing, he's getting privately paid for news service to the people. I'll give you a bit of news if you want. Do you want a bit of entertainment or a bit of chit chat? It's Rees-Mogg. You get to know me a bit better, and I'll give you it all for free. If obviously people can come and vote for me now they know me, but it's not being paid for by his political party, is it? John Evans of Bridge Street. Offer £5 for votes. But this is specific to elections, isn't it? I don't know how it goes with handbills though, because the thing with a handbill is you're giving someone a handbill or a advertisement or notice, hopefully that they're going to get people to support it or sign, and they're giving notice. But what you're doing is you're asking people for statements. The flyer, the sticker, the handbill, the notice is actually a representation. It's not actually considered as a gift or money itself, because it's actually an advertisement or representation. That's the thing with all. You see, this is why really that statutory instruments, town and country planning, is completely exempt, because then it's all those type of things that you're expected to be used are covered for like all your banners, flyers, stickers. I guess it really covers the rosettes, because it says vote for Insanity, vote for Monster Raving Loony Party. It's like a rosette handbill advertisement rosette thing, kind of. But yeah, okay, it's a gift, but it's still an advertisement for the campaign, which is there to ask people. But these are all in return for reward or favour. This is why I've got an issue with, the notice of intended prosecution. The fine's £80, but if you pay it within so many days, it'll only be 40. As long as you confess and admit your guilt. This is why I think the whole notice of intended prosecution is particulars, domestic interest expenditures. These are all prosecution. These are all people. Look, these are all people who've been. See, Sue Hall is. I don't know. I'm not. Maybe because they're giving money to the camp. Are they giving money to the campaign or giving assistance to it? But if they're having meetings, all in exchange for a vote. Well, yeah, because what Sue Hall's doing is she's saying, like, if you, she's saying, if you vote for me and help me get elected, I'll turn the cameras off. But she's already been, the Conservative Party, of which she's a member, have already been given the current the petition bag, which buys the resolution. They've already got it, or they've already got the right to have. Well, that's the party who say they're going to turn the cameras off, but they're not. They're not turning them off. They're blackmailing, because they're saying, we're not going to turn them off or give you a resolution unless you vote for Sue Hall. So that's just a blackmail. That is actually a Conservative Party blackmail, which actually involves the Mayor of London as well. I'm sure that give parcel of remnants for vote. Promising to give parcel of remorse for vote. Giving railway ticket to secure. Who's giving people railway tickets to? Place. Promising to make up any loss to business caused by voting. Wow! Promising to make up any loss to business caused by voting. Well, aren't the Tories saying that, well, all the people have lost business for Khan, haven't they? All the people have lost money to the whole ULEZ fine system for Khan. And it's going to make up for lost business if Sue Hall turns it off. But they've already got the right to that. They're promising to get daughter into Ashford High School if husband would vote for respondent. Oh, so that's doing favours for. Well, how can you have policies? How can you have policies? It seems like you can't have for individuals. Struck out in chambers. We can sponsor. What about their agent though? Because the agent is. How does the agent even work to get votes? Well, I suppose the agent is acting on behalf of the candidate and the sponsorship. They can receive money. Or treating to drinks. You're not allowed to buy them drinks either. You're not even allowed to buy them a drink. You're not allowed to buy them a drink. I wonder if Sue Hall has bought any of them a drink when they went out. Or Khan. I wonder if Khan has. Well, what's he going around? Oh, he's going around flyering, which is actually promotion. I don't think the rosettes count because it's an advertisement. I wonder if I think some of these councillors, with these corporate entities, and like football tickets and things like that are getting into this territory, and they're like contractors and for decisions in council. I think that there's something definitely dodgy going on between like football clubs, local councils, bus companies, and executives and members of the council getting bonuses and things for chamber decisions. Treating to drinks. You're not even allowed to buy these people a drink. Standing drinks all around. Give £1 to landlord for treating to drinks. Wow, that's something interesting. I'm sure Khan has bought people drinks. I won't be surprised for votes. They're going round and walking round, doing like flyering, and like obviously you can do that. It's canvassing. Where was that? 22 and 23. Where is the actual 22 and 23? Tamworth, Taunton, Tewkesbury case, Norfolk case, Kennington, Galway, 22 and 23. Oh, the excuse that's I want to find this excuse and exemption for corrupt. Hold on a minute now. Right, I found it now. I found this section 22 and 23. But the thing what I'm thinking is the equivalent of what we're looking at with this corrupt and legal practices for petitions, it's not really so much just about, like, you know, like Extinction Rebellion. It actually encompasses the actual whole thing. So it's like not only the people who are signing petitions and the candidates, so the people who drafts it, it encompasses the whole running of it. So that would encompass the petitions committee as well. That would encompass the petitions committee. So it's actually not only the people who are signing them and sharing them and collecting the signatures and submitting them, but it's also the running of the committee as well. What the committee are doing. And they're unlawfully rejecting things contrary to what the rules say. They're failing to provide enforcement. So the actual equivalent of this election petition trial is like against not just you. If you, like Extinction Rebellion, are breaking the law and breaking windows when they're trying to be collecting signatures and promoting things, but it encompasses and includes the actual petitions committee itself, its conduct, the 11 members, and I would say 38 degrees, because 38 degrees have taken down 3 of my petitions, stolen them, all the signatures from me. Now, they claim that some of the signatures were illegitimate, but that's for Parliament to decide and judge, and for Parliament to deem whether they should be set aside or not. And if I didn't collect them corruptly, the people who signed and the agent responsible. So, what the law says is that they're just set aside. They don't count. To be honest, in these early election rules, you don't have any spoiled ballots, because all the ones that they can't read have got to be checked. And that's why they've got a number on, so they can contact the person to clarify. So you don't get like now where you got those spoiled ballots, because you can contact them to sort it out. So, you know, this is the thing. And if it's invalid, this is the... So it actually brings in the scrutiny of the 11 Parliament members, and they can't use privilege then. So what we're looking at is not just Gail Bradbrook. We're not just looking at, XR breaking windows. We're actually looking at the whole process, Why did they do that? Well, they're saying that they tried the petitions, but they didn't work. But who's got the cognizance of petitions? Well, the public have got a certain cognizance on petitions and signing it, like in elections, right? But they might be judged by the Parliament, who wins. But if you have a referendum, then Parliament don't have the cognizance on the referendum. The people have the cognizance on the referendum, and then the Parliament just have to, order it, put like in the jury in the court. So the people have got a cognizance in Parliament if you get enough signatures for a referendum, but you've got to have evidence that enough people are concerned about it, which is part of your evidence. So the 11 petition committee. And because I found out the petitions committee are under the Judicial Conduct Investigations Office through the Constitutional Reform Act 2005, representations to the House of Commons, then it's effectively like the Star Chamber Committee, but it's Lord Chief Justice. So actually, the question of, who's been breaking the law concerning petitions is included within the same cases as the Petitions Committee themselves, who are rejecting them. Why are these people all on the streets kicking off? In fact, for Dave Fowler and Tim Rowling, why are they cutting ULEZ cameras down? When Dave Rowling, Tim Rowling, Dave Fowler, Tim Rowling, and John Wisconsin, and Sue Hall has been handed 200,000 signatures for the Prime Minister to get a resolution in Parliament, but they're blackmailing everyone and saying, well, we're not going to give you a resolution unless you vote for Sue Hawley to elect her into the mayor. Then we'll give you a resolution, our party will. That's blackmail. And the Petitions Committee, all these rejections, and then 38 Degrees are stealing petitions and taking them down when they don't have the authority to judge it. It's got to be judged by this proper lawful process if there's something wrong. They don't have the right to intervene. And the publishing of petitions, like on 38 Degrees or in the newspaper or in print, is actually meant to be enforced by the Petitions Committee to keep them up, not take them down. And if they are, and they can't judge if any signatures are legitimate or not until you've finished, until you hand it in. So 38 Degrees are actually now liable. I'm going to, at this point now, I'm going to bring 38 Degrees into it and those 3 petitions that have been taken on unlawfully. And I don't think this is now peculiar to one petition case. This corrupt and illegal practices of the Petitions Committee now, it's evidently clear it's a large number of petitions. It's not just peculiar to my petitions, but to how the committee are dealing with many petitions and how they're being prosecuted. So it's the whole thing. It's the whole thing. We're getting prosecuted by the police. They're refusing to run many of them, and people are resorting to go in the streets when they had a special case management process through the Tumultuous Act to ensure that everyone got recognised and assessed for large numbers of people before they proceeded, and they don't have that anymore. And Parliament actually demand more and more and more and more people, which is going to create more and more large groups and more chaos. And they're refusing to even many of the cases to put them. The whole thing's a complete and total. And then the evidence that we want to help to prove it, I'm having to look and refer to the similar but exceptionally relevant election petition rules, because that's the closest thing that we've got, which clearly creates and specifies a very, very special process, because you're doing something very, very particular and unique in law, not a standard police, local crime or civil case. So we'll just so I'm going to have to call in the and Judicial Officer Conduct's going to have to sit through this whole video and listen to it all. I'll have to tell them they'll have to, because this is the evidence. I'm going to have to cite those. I'm going to have to cite those 38 Degrees cases now, when those 3 petitions that have unlawfully taken down, because there's no enforcement from House of Commons. So they need putting back. I've written complaints into them myself. I was going to even take them to court, but why want to take them to court when it's part of the? This falls under the Judicial Conduct Investigation Office. The 38 Degrees is part of this. Well, it's not just scrutinising my actions or Extinction Rebellion's crimes. It encompasses all parties involved in those petitions, and now not just this person's or that person's, because it's how the whole thing's been run. So it definitely is under the Judicial Conduct Investigations Office, because it is the chairman of the Petitions Committee. Really, they're really not competent or capable, and it's a Labour Party woman at the moment, and I really, the privilege, they're not allowed to use privilege either. They're not allowed to use the privilege as an excuse. They're not allowed to use privilege as an excuse to fail to give evidence and answer questions, and also they can be removed from position. I don't know if they can be prosecuted criminally. I think that it's a bit different to Lord Hindfield in Suffolk Crown Court. Whereas upon excuse and exemptions of corrupt or illegal practices or illegal payments and employment of hiring But this would be like then the committee members now. So if I'm accusing the petitions committee of illegal corrupt practices as well, that's like the same for them, as well as the people involved in bringing the case as well. Where upon the trial of an election petition respecting an election for a county or borough, the election court report that a candidate at such election has been guilty as agents of the offence of treating an undue influence and legal practice or of any such offences in reference to such election, and the election court further report that the candidate has proved to the court A, that no corrupt or illegal practices was committed at such election by the candidate or his election agent, and the offences mentioned in the said act report were committed contrary to the orders and without the sanction or conveyance of such candidate or his electoral agent, and that such candidate and his election agent acts complained. Well, see, this I'm concerned about this now for when I did get I kind of asked someone to, I employed an agent to, promote the petition to collect signatures, but that agent actually brought some sketchy signatures in. So that I don't know whether that I don't. If I don't know they're doing that, and if they deceive me, then that definitely is their fault, not mine. But this is kind of suggesting, well, candidate or their agent. I don't think the candidate's responsible if it was his agent. So it's candidate or his electoral agent. What about 38 Degrees' website anyway? There's got to be a hell of a lot of petitions being handed into government that have got sketchy, dodgy signatures from all those change.org petitions and a lot on 38 Degrees as well. A complaint agents acts complained of have been done by the candidate or his agent. The court held that this was a good objection and refused to amend the petition. This complaint have been done by the candidate or his election agent. The court held that this was a good objection. Complained of had been done by the agent, where there were two candidates responsible to the petition, Wright and Bruce, held throughout some doubt that this subsection might be read as applying to each of the candidates separately and granted relief to the one refusing each other. What about when Facebook are removing petition signatures like Mark Zuckerberg, and there's Nick Clegg's working there as well. Nick Clegg's working at Facebook when Mark Zuckerberg was removing my Broxy Kennels petition signatures and advertisements from there. And Nick Clegg's might be ex-Deputy Prime Minister for Liberal Democrats. Granted relief to the one while refusing it to the other. Or granted relief to one while refusing it to the other. This is to do with actually, like, if you're wanting to get things printed and they refuse service to you but accept it to someone else, or in the newspaper as well. Things like that. When the candidate took part in a procession, where the candidate took part in a procession around the town in which the court was satisfied that a good deal of drinking took place, and that he must be taken to have known that there was at least a danger of treating. The court refused to find firmly that this candidate took all responsible means to prevent corrupt treating. Wow. So like when Sue Hall's going out with all of the Get Carn Out and supporting her, they're all hanging around together and having meetings in public. They don't actually have to have done anything wrong, but there was a good chance of it going wrong. Apparently, according to this, in absence of such a finding held that they had no power to relieve against an illegal act. They had no power to relieve against an illegal act, though of a trivial, unimportant, and limited character. The court refused to find firmly that this candidate took all reasonable means to prevent corrupt treating, and in the absence of such affirmative finding held that they had no power to relieve against an illegal act. Well, if you do have power to relieve against an illegal act, it's a bit of a contradiction. There's some element of contradiction in this. There definitely is some element of contradiction with this indemnity, and the whole 1688 Bill of Rights clause seems to be almost a riddle. That it's like, judges, if they corrupt, they get prosecuted, and the election is deemed not viable, but the judges themselves don't suffer. So, is this against the illegal act? Such means prevent corrupt treating, absence. So that's the thing. I don't know if the corrupt treating. I don't know whether that involves the actual electors, the voters, the people, or they're just a candidate, or how so far it invalidates the election. I think that if they give money for someone's vote, then that person's vote doesn't count. I think that's what I think. If I'm reading this right, I think this is more like to do with like the validity of the votes and therefore the integrity of the election, rather than the capacity to punish and convict. Took all reasonable means for preventing the commission of corrupt legal practices at such election, that the offences mentioned in the said report were of a trivial, unimportant, and limited character. So you can, there were offences, they mentioned them in the report, but they were of trivial or unimportant and limited character. Well, Rees-Mogg definitely is not himself of a trivial, unimportant or limited caricature when he's on GB News receiving monies privately, which is tax-paid money, which is definitely not non-profit, going to himself for his own personal profit, which is actually promoting himself as MP for South West Somerset or whatever it is on GB News, when otherwise he would only appear on television as a guest, unpaid, and be promoting himself taxpayers' money, because that's his job. We pay him to turn up on the news. The taxpayer is non-profit, but that's part of his job as an MP. He gets a salary for that from the government, and any of his appearance non-government must be through his own campaign and paid for by his own campaign, paid for by the Conservative Party, because that's who he was running for. He's running for the Conservative Party, and he's actually getting paid by GB News, and it's not non-profit money, because Conservative Party money is non-profit. It's not for profit. We're promoting anything that helps Conservative Party or yourself in an election. It's got to be non-profit. But he is getting self-promotion for profit, and tax is being paid on that as well. The offences mentioned in said report are of trivial, unimportant, and limited caricature. Well, that's Mogg, isn't it? That is Mogg. He's not he's unlimited. He's got an unlimited caricature now. That is being, he himself is being treated by GB News Apparently GB News is a service, entertainment, as treating the public for votes. GB News is a form of entertainment for the public, and they watch it, and Mog is giving them the... Mog is, and it's like Robert Williams, let me entertain you. Mog is entertaining people and being paid for it for profit. So Jacob Rees-Mogg is giving a tree of entertainment, because that's what it's to entertain people for private business, that is giving him a while he's an MP, an elected candidate, also increasing his popularity, and treating people in return for, definitely in his own constituency, or possibly any that he might run for and can run for in the future, for his popularity now while he's in serving. And it's not being paid for by the Conservative Party. It's not being paid for by the Tories. It's not non-profit. He's treating the public to an entertainment, and himself gaining a profit personal. And the Conservative Party, in his caricature, is being promoted, which, you know, he wouldn't be in that position if he weren't an MP. And, you know, when he comes on the programme, if he's self-promoting as an MP, as a guest, he is there. He's not getting money from the station. You know? He's under the employment of the public. You know? He gets a wage to do that job. And, by the way, that job that he's in is not taxed because it's public funded. So that's not taxed anyway. And the Conservative campaign is meant to be not-for-profit. So, you know, this character business... that in all respects, the election was free from any corrupt or illegal practice on the part of such candidate. You see, this goes for Johnson as well, with his newspaper column. Same thing as Mogg. That in all other respects, the election was free from any corrupt or illegal practices on the part of such candidate and of his agents. Then the election of such candidate shall not, by reason of offences mentioned such report, be veterinary candidate shall not be reasoned by any offences mentioned in such report be void. That the offences mentioned in such report were true, that in all other respects the election was free from any corrupt or then the election of such candidate shall not, by reason of the offences mentioned in such report, be void, nor shall the candidate be subject to any incapacity under this Act. So it's all about the actual casework being valid or not, rather than the punishment of the individual, which is what I'm saying for the right to petition and bringing a case to Parliament, you know. But the thing is, when you're bringing a case to the thing with the election is that you are gathering all the signatures to show that someone was elected, right? And obviously that needs to be a proper process. When you are bringing a case to Parliament, you are bringing a case with evidence to get this or that action from Parliament, and they're going to look at the case and evidence. Now, whether that procedure was lawful or not is to do with your actions. Did you break the law? What about the committee that you're bringing it to? You know, this is the thing. So that actually, for the equivalent for the House of Commons, as opposed to an election petition, like I say, this pulls in 38 degrees. It pulls in the actual 11 petition committee members, possibly even the Prime Minister, and as well as, you know, Gail Bradbrook. And the thing, it's like the whole thing. And when these things get to court, it's just been treated as a completely irrelevant, it's not actually even acknowledging what even you're doing. and it's actually it's a special type of proceedings, kind of more civil, that does have a prosecutor, but it's peculiar, and there's indemnities. People are brought in as witnesses are getting certificates of indemnity and so forth, and then there's all these excuses. But we get the thing when you're doing the right to petition under the 1688 Bill of Rights, the right to do that gives you a certificate of indemnity. That's what it does. It actually gives you a certificate of indemnity. But obviously they want to see everything's done properly. But the thing is that you're wanting them to see what you're doing because you're actually gathering informations to give it to them so you can give them informations and show them informations, but they're not even letting you do that. They're actually either not letting you run the petitions or even omitting evidence or so forth, and even not even giving support for advertisements. They're also telling the 77th Brigade to take certain things down from the internet and so forth, which that is part of it as well. 77th Brigade are actually part of it. Because they've been, apparently Big Brother Watch have said that they were taking some of those things down. And then this is when the Petitions Committee aren't giving enforcement to for the platforms and for the newspapers and for compelling the printing of documents that are going to be used as witness statements and to share the petitions as directed by the Petitions Committee. Does its report body candidate subject to an incapacity? When applications are made, is to show to the High Court or an election court by such evidence it seems to the court sufficient that any act of omission of a candidate at any election or his election agent that any act of omission of a candidate at any election or his payment, engagement, employment or payment, engagement, employment, and contract. Power of High Court and Election Court to exempt innocent act from being illegal practice. Power to exempt an act from being an illegal practice. Oh, it says the offences. So they're actually illegal. Look, let's get some clarification here. That the offences, illegal, unlawful against the law. The offences in law mentioned in the said report were of a trivial, unimportant and limited character. Offences. So that's to the police. That in all other respects the election was free from any corrupt or illegal practice. So that is like the operating and running of it generally in the evidence that you're bringing and giving and going about, collecting your signatures, promoting and advertising it. The election of such candidates shall not, by reason of offences mentioned in such report, be void. That's like the petition to Parliament shouldn't be void, nor shall the candidate be subject to any incapacity under this Act Well, this is the Act that facts and circumstances are given. And this is what gives you this certificate of indemnity from disclosing such. But that you should never have a criminal charge against you because it's not being brought as a special proceeding. That in all other respects, the petition was free corrupt practices and reporting, where an applicable made is shown to the High Court or to an election court by such evidence it seems to the court sufficient that any act or omission of a candidate, any election of his election agent or any other agent or person would by reason being payment, engagement, appointment, contract. The law intends by this and the next section to enable judges to relieve candidates from all responsibility for corrupt and illegal practices. What? It starts to make you think, what is the law intends by this and the next section to enable judges to relieve candidates from all responsibility for corrupt and illegal practices. But that's the candidate, though, not necessarily the people who are running it and hosting it and so forth. So that would not be like, the petitions committee when you're trying to get petitions in and bring them and so forth. It would just be the person who's written up and drafted it and collecting signatures. Where they are satisfied, the judges, that they have done everything on their part to render the election pure and free from corruption. When they satisfy the judges that they have done everything on their part to render the election pure and free from corruption. But on the onus lies on the candidate and his election agent to prove, if they ask for such relief, that they personally took all responsible means for preventing the commission of corrupt and illegal practices. The application is made by motion of the original court on the application of the judges and chambers and the... It's insane when you think of the police, isn't it? Did the police do everything they could to ensure there's no corrupt or illegal practices? Well, the thing is, corrupt or illegal practices, the thing is, what the police does is illegal to everyone else, but supposedly not to the police, but they've got their own guidelines in the law. But then what's legal or not legal is different to what is corrupt of the actual practicing of the whole thing, It's kind of ridiculous in a way, because the right to petition says it's the right of the subjects to petition the king, and this is not a police officer bringing a case to a local court. But all the prosecutions are illegal, all of them. It just means you can't be imprisoned because of the claim of right for it. The law intends by this act section to enable judges relief. Such relief. Application divisional court application to judges and in chambers and in either case made on part after notice. It may be made on affidavit. May be made on affidavit for a precedent of such affidavit decided under the analogous section 20 of the Municipal Corporations Corrupt Legal Practices Act. You can reduce this act to being payment of a sum of incurring expenses and expenses which were not allowed in this act to otherwise be in contravention of any of the previous for the section of illegal practice, payment, employment or hiring, and that such act or omission arose from inadvertence or from accidental miscalculation or from some other reasonable cause of a like nature. Why is there an X there? And in any case, did a printer guilty of an offence? A printer? I'm getting into printers now. A printer is guilty of an offence against section 18 is not within this subsection unless he knew he was acting in contravention of the act in which he is not within the next subsection, X party. Inadvertence, accident, miscalculation, some other reasonable excuse of a like nature. This section is intentionally very carefully guarded and has always been limited by the courts to a small and accidental mistakes. Held that a candidate was guilty of illegal employment and illegal payment and in employment and paying persons to tout for votes or to distribute canvassing handbills. Oh, we've got into handbills now. This is great. Look at this. Was guilty of illegal employment and illegal payment in employment and paying persons to tout for votes and to distribute canvassing handbills. He excused him under this section because the act was new and by no means easy to master, and the blot in question was so far from obvious that opposed counsel did not rely on it until the court pointed out its bearing, but he might hold otherwise, he said on a future occasion. So, a blot. So, are they saying that he spoiled, or like a spoiled advertisement, a spoiled handbill? The printer spoiled a handbill. Paying persons to tout for votes, possibly even paying a printer to spoil handbills. Well, they're paying Jacob Rees-Mogg to tout for his own votes, but it's not funded by the Conservative Party, non-profit. That's the problem with Rees-Mogg. He's been paid. He's actually making a personal profit and taxable promotion, self-promotion, which is definitely touting for votes for him. And it's not paid for by the Conservative Party's official campaign, which is meant to be non-profit. So that's it for Mogg. Mogg's done. Mogg's done. He's just a ghost on GB News now. He's like an apparition. He's gone. I mean, he's just like an apparition now. Like on the Ghost film. Still there talking, but he's gone. A messenger was excused as inadvertent, rested his decision on the ground that the that the part of the act had never yet been interpreted. It does not therefore follow that the same excuse would be allowed now. Well, what about the right to petition being invented? It may either be that the party was not aware of what was done or that it did not know it was wrong. Where streamers hung across the streets were held not arise from any want of good faith, and that such notice of the applications being to be banners respect to the election agent might duly say that the payments for them were inadvertent to the latter sense, and the payment was therefore excused under this section. Cards for hats. Cards for hats had been made specially adapted for being placed in hats. Returning good faith interrupted either by the respondent or the electoral agent. The court refused to excuse this from being an illegal practice. I think it's definitely gesturing. I'm going to call that it now because I can't be bothered with it anymore. I don't want to have to read this whole book now today, but I'm pretty certain that it's what it's doing is it's acknowledging the fact that not everyone knows the Bill of Rights, understands it, not everyone agrees with it, or even judges, and that there could be some political dispute over the law, even though it is the law, the problem is that the 1688 Bill of Rights, right to petition, if it covers election petitions and other forms of petitions, then it kind of gives license and permit to corrupt practice. So how can anything be legitimate? Well, how you solve that problem is making sure that you can sort it out, even though people aren't liable to be punished for it, but making sure that it can be investigated and actually sorted out, and whether the process is deemed legitimate or not, or judged legitimate or not. That's kind of where I am with it now. Although, you know, this is when judges get onto ridiculous subjects like, oh, you can't go around killing everyone or something like that. But, you know, the 1688 Bill of Rights has got other clauses like standing army and, you know, you can only bear arms for defence. So it suggests that you can't attack other individuals and so forth. So there are clauses in the 1688 Bill of Rights which give some parameters of behaviour and conduct and what is acceptable or not within that bill, which is not, you know, armies and attacking individuals for certain. It seems like the particulars of any petition are kind of like arguable, negotiable or debatable, but the thing is they're not being under the premise of the petition. The police are coming in with completely independent charges in regional areas which don't even regard it as a petition or a special process, and therefore the reasoning of people's conduct and behaviour is not being brought with the other it's not actually being brought under a special action or special proceedings. It's just being brought under normal ones, and I think that's the difference.